is?
So a cached image, the best way that I was kind of taught it is when you think of surfing the web, what you're actually doing is actually downloading the web to your device. And part of the reason that happens is just for the purposes of allowing your device to potentially reload things that you frequent. Just because something's cached doesn't necessarily mean it's a frequently viewed thing. However, when you, for example, scroll through Instagram, as you're scrolling through Instagram, it creates thumbnail or representative images on your phone within that application, so that if you scroll past those again, it will load.
Yo, why nobody told me it was hot as hell outside, man? I went outside, man, I sweated to death, man. What the fuck? Y'all gotta warn a nigga that it's 100 degrees outside. What the fuck?
Faster, and those are cache images.
So your phone's essentially remembering the images it's seeing.
Correct.
I'm going to go down. I think this is going to be going on to page 5 here. Were there cached images of Sade?
Yes, correct.
And to clarify, there can be cached images that were taken by the device itself, right?
Yes, yeah.
So like if you took a photo with your phone would also cache that?
Correct, for various different reasons.
All right. So it's not, my point is it's not just web surfing or social media browsing.
No.
Your phone is doing that throughout whatever apps.
Correct.
Okay. What do we have here on page 5 on the screen? I have it up next to you.
So there were a total of 10 images that I found from this time period that were cached. These are just 2 representative images from the application Instagram of someone that appears to be Sade.
And when you say this time period, what are you talking about?
So it would be the timestamps that the cache images were, which I believe was, here I have to look.
What timestamps were images of Sade cached?
7:33 p.m.
On what date?
This would be the 1st of April. My apologies.
On the screen now, are those 2 of those images?
Correct.
All right, let's move ahead to 10:07 p.m. What starts happening on the phone at 10 o'clock?
So from 10:07, 10:09, 10:12, 10:22, and 10:57 p.m. on the 1st, I start seeing usage of the camera. So everything on your phone is a different application. So basically, you see the application that's built into the Samsung. Pull up the camera application.
How is it that you're able to see all this again?
Because with any interaction with your phone, if you kind of think of like either Domino's or Rube Goldberg or something like that, just because, for example, you are just clicking on a photo, for example, and it pulls up, there are a litany of different things that are happening behind the scenes. So, and I think it's further in the report, you'll see that things are being stopped and started so that different system resources can get access to those applications.
So you were able to tell that in the 10 o'clock hour, it looks like on 5 occasions the camera on the phone was activated?
Correct.
Would that require user interaction with the phone, human interaction?
Yeah, it would.
What about after that?
After that, there is somewhat of a lull in usage, and then until the next morning, I would say.
All right. What did you notice occurring on the phone at around 12:05 a.m.?
So at 12:05 a.m., a user unlocks the phone, and the phone's display turns on and goes to the last activity that would have been happening on the phone, which in this case was usage of the gallery. So like if you scroll into your phone, your gallery, just your images.
At 12:05?
Correct.
Is that what I have on the screen here, or am I in the wrong spot?
Yes.
Okay. And specifically 12:05 and 37 seconds a.m.?
Correct.
And what gallery specifically are you talking about?
So this would just be the regular Samsung gallery. So if you click in it to look at all the photos you've taken.
photo gallery.
Yes, correct.
Okay. And then what's happening after 12:05?
So after that, and this is kind of where I get into that whole dominoes or Rube Goldberg, as you press on things, the user transitions to the camera application, which pauses the actual gallery application because they're technically two different applications, even though they're kind of morphed together, which then subsequently stops usage of the gallery itself.
And how often does that occur starting at 12:05?
I would have to look specifically, but I believe 3 occasions.
All right, well, let's just keep going. So at 12:05 and 38 seconds, what happens?
So at 12:05 and 38 seconds, the camera is launched, which is then launched with a third application, the launcher, which launches and pauses things, which then causes the phone itself to stop the gallery application.
What happens next?
Then after the gallery application stops, several seconds later, the camera pauses because it goes back to, or not seconds, milliseconds later, the camera goes back, or the camera pauses and goes back to the gallery application.
And does that interaction then stop?
Yes, and then a second later, about, the camera application stops.
After that,
the gallery application is once again paused and the camera is launched again several seconds after that.
and by 12:05:42, what's going on?
12:05:42, oh, I think I skipped ahead. 12:05:42, I see that there is some interaction with a cache image. I can't determine what that interaction exactly is.
Okay.
So there's a modified date to that. So there's some sort of interaction with the photo.
Then what happens next?
Then the gallery application is paused.
What continues to happen until 12:08?
So until 12:08, this kind of sequence of events happens until there is, like, it goes from camera back to gallery, and then there is a period in between there when it the pattern of usage appears that the bunch of images are deleted.
Tell us about that. What time does that happen?
So the deletion period begins at approximately 12:05 and 53 seconds. It starts, there's an interaction with about 32 cache images.
Is that what I'm highlighting here on the screen?
Correct.
Okay.
Now, the interaction with those images, it could have been more or less of those images. Those are just the images that the cache was left over from after that period. Shortly after that interaction, there is a the delete services of the phone begin. So it starts deleting, and then a millisecond or so after they hit delete, there's a notification interruption. And that notification is simply the phone saying, "Are you sure you want to delete these images?"
Okay, so I just want to break that down a little bit because that was a lot, and a lot of lingo too. At 12:05 and 53 seconds, there are 32 images that you identified as having a modified timestamp. Is that correct?
Correct.
Do you know what modified means is happening to those images?
Yes, so there's interaction with those images.
Human interaction?
Yes, human interaction.
This is not the device doing
it's
itself
not
on
the
its own?
device. Yeah.
Okay. And are you able to tell what happens with the human interaction to those images?
Based on the time frame and when the phone itself actually has in the actual timeline itself, the next actions that happen within that system is deletion.
Of those images that were deleted,
It is highly likely that it was of those images.
okay. And included in those images, were there images purported to be of Sade Robinson?
Correct.
And I'm going to scroll down. Are these those images?
Yes.
This last one was modified, correct?
Correct, yeah.
Purposes of presentation.
Yes.
All right. Are you aware, for that particular Samsung phone, what a person practically would have to do to delete those photos?
So yes, I did actually a lot of tests with this with an actual Samsung S22, so I could verify what I'm talking about. They would have to go into their gallery, essentially select all of the images, and then hit delete, and then that notification pops up and says, are you sure that you want to delete these images? You hit yes, and then they're gone.
And is that what happened here?
Yes.
What happens next? I think I have up here, is this the delete service?
Yeah, so like I said, phones are just a bunch of applications. So there's an application for deleting those applications within the actual gallery application occurs. It stops shortly, several seconds later, and then it eventually is started again several seconds after that.
What started again?
The deletion is started shortly after it stops again.
Were there more images deleted?
It is more than likely that more images or videos were deleted at that time.
Okay. Were you able to see which images?
I was not.
But in the prior instance, you could see the 32.
Yes, correct.
What happens after 1206?
After 1206, you mean 1206 and 35 seconds?
Sure, why don't you just keep taking us through it?
1206 and 35 seconds, there's that notification interruption. Then shortly after that notification, the delete service is stopped again. And then again, several seconds later, the delete service is started again. Notification happens at 1206, several milliseconds after that. And then the service is stopped. And then the gallery, which is where the delete services are happening in, is then paused and the camera is launched again.
What time is that at?
So the camera is launched at 1206 and 56 seconds.
Does that necessarily mean the camera's being used to take photos?
Not necessarily. I mean, could have accidentally hit the camera application.
After that camera is launched, what happens?
After that, almost simultaneously, obviously the gallery is paused, and then shortly after that, the camera is paused and a user goes into the phone settings.
Okay, what happens once the user goes into the phone settings?
So the user is in the settings for about 20 seconds or so, maybe a little bit longer.
Beginning at what time?
Beginning at 1207. Well, beginning at 1207, they're in the actual settings application. The first configuration change within the settings is at 1207 and 23 seconds. And then again at 1207 and 25 seconds.
And what's happening there?
So essentially, a user is changing some form of network settings. Unfortunately, because of how some of this stuff is recorded, I can't tell what exactly those settings are specifically with network. Certain network settings will only tell you what the last state of the settings were. So if you turn on or switch Wi-Fi or any of those types of things, it's gonna record the last state that it's in from the time that it was downloaded.
By network, you're referring to like the cellular network that's servicing the phone?
Yeah, either cellular network, Wi-Fi, any of those things, Bluetooth.
What happens shortly after 1207 and 25 seconds?
So shortly after that, there is a notification from the operating system that pops up. I don't know, again, what that notification was, but...
A phone notification?
Yeah.
Not something the user's doing?
No, not something the user's doing.
And then what time is that at?
That is at 1208 and 38 seconds.
All right, now this is beginning after 1208 and 38 seconds. What are you seeing?
I do not see any user interaction.
Is So
or human user interaction.
human user interaction. When is the last time that you see human user interaction with that Samsung phone?
So the last time that I can determine that there is any human user interaction for sure is at 12:07 and 25 seconds. There's possible human interaction for that 12:08 time period that caused that notification, but it's also likely possible that there was some other system thing that popped up because of it.
Okay, so let's just assume for the sake of argument, it's the latter one, the 12:08 one.
Correct.
Do you see any human user interaction on the phone for the rest of that night for hours?
No,
That's the last time?
that is the last time.
Until when?
Until the next, well, not the next morning, several hours later at 8:59 a.m.
On April 2nd.
on April 2nd.
So from 12:08 a.m. to 8:59 a.m., are you saying that there was no human user manipulation of the phone?
Yes, there was absolutely no human user interaction.
What happens, and I have on the screen here, is this is you documenting that?
Correct.
Okay. So in sum, can you just, and I think it's up on the screen here, but just summarize briefly what exactly we're seeing occur between 12:05 and 12:08 on the phone?
So a user is going between the applications and the camera back and forth several times. Then they begin deleting things, and then there are some form of configuration changes in the settings, and the phone is not interacted with
After 12:08?
after 12:08.
And in there, we know that the camera was used.
Correct.
Okay, and so you know that there was camera usage from that phone after 9:20 p.m.?
Yes.
What happens after that? I know you said there's no user interaction, but as you go
Yes.
forward, you saw some things?
Yes. So at 12:17, so approximately 10 minutes or so, maybe a little bit less than that, later, the phone registers itself as being inactive. So the screen goes into an inactive mode, essentially like a somewhat, I guess you could parallel it to like it goes into sleep mode. The screen still stays on, but the phone is in a sleep mode, which then pauses the last application that was open, which was the settings.
So that's not a user doing anything?
No, that's the exact opposite.
Okay. After that,
So then settings are stopped almost simultaneously from that period of time.
are you able to conclude that between 12:45 a.m. on April 2nd and 8:43 a.m. on April 2nd, there's no user interaction with that phone?
I can 100% include that.
There's some notifications that come in, though, overnight, right?
Correct.
Tell us about that.
So when you have social media, there's different types of timestamps and everything when it comes to digital media. There are the timestamps that are recorded from when you are interacting with your devices that are changing those timestamps. And then, for example, when you're talking about social media, email, really anything network related, there are also timestamps from, say, the other person who maybe posted it or sent you that email. Those timestamps are going to be from likely when the actual email or post was created, and that is registered to whatever server is hosting whatever application that is. That created timestamp doesn't mean that somebody's actually interacting with that on that specific device. It's just the time at which that was registered to outside servers.
There were some of those overnight after 12:08?
Correct.
Okay. I have one on the screen here, 12:49. There was some kind of social media notification.
Correct.
And then 12:59.
Correct.
Okay. What starts happening at 1:21 a.m.?
So at 1:21 a.m., the phone screen officially turns off. And then shortly after this, there is a notification that comes in, and it's about 2 or 3 minutes after that, there's what's called edge lighting, which I don't know if any of you have Samsungs, but essentially the idea is that when you get a notification, the outside edge of the phone lights up to let you know there's a notification, even though the screen is off. And then 4 seconds after that, it lights up again just to remind you that the notification is there.
All right. Then what happens?
And then the phone begins to power off.
Describe what happens to the phone.
So the phone had a low battery state, and the phone essentially dies. So as a phone is dying, essentially the phone starts moving different things and energy towards more important aspects of what the phone actually is meant to use for. So for example, if you're out in the woods and your phone is dying, the last thing that's going to probably turn itself off before dying is going to be your ability to call for help. So certain applications, so the screen turning it off, it was going into a low state, and then the phone kind of starts checking itself to make sure that is there really not power, or is there something else going on with this phone? Doesn't mean it's not going to turn itself off, but that's essentially what happens. So this artifact, essentially I don't know if he's got that up. Oh, so the Samsung Wellbeing gives you the ability to kind of look at your own phone usage. So it starts recording that the phone is powering off. And then there's an internal application that usually doesn't necessarily parse out with a lot of forensic tools called the ERR.P, which I guess the name is, I guess, irrelevant. But what it is it records different powering events on the phone. It records, for example, when the phone is factory reset or first set up. It records when a human user turns off the phone. It records when there is a shutdown and power up related to a system. So like when you're updating the operating system of your phone, it frequently has to turn itself off, and then it registers when the phone dies. In this case, it registered that the phone died due to lack of power.
And at what time did the phone die due to having no power?
At approximately 1:35 and 57 seconds.
Is that what I have highlighted here?
Correct.
Okay. And below that would be the artifact that you're talking about?
Correct.
That is not the same as someone physically turning the phone off, right?
No. So if the phone is physically turned off, this artifact registers it as an unrequested because it's essentially monitoring the system itself. So if the system requests that something be turned off, then it'll be recording why it was turned off. If a human user interacts with it, it is listed as unrequested.
And were you able to identify the next time that the phone was connected to a power source or had power?
Yes. So the phone at about 8:59 in the morning.
8:59 a.m. on April 2nd?
Correct.
And what did you see?
So the phone registers that there is no power, and it goes into a low power mode, likely due to a phone being plugged into a charger.
And then how about when the phone turns on?
The phone officially turns on at around 9:20 in the morning.
All right. And throughout the night, there were other notifications, right? But the phone was off?
Correct.
And when you're seeing those notifications in the phone, are you seeing obviously the time they would have then received or gotten to the phone, or what?
No, we are seeing the time that those were created.
All right. So I have one up here. For example, at 2:09:32, the phone would have been dead, right?
Correct.
But nevertheless, you're seeing this Facebook notification that I have highlighted here.
Yes, so that would be the created time of that post on the news feed.
The created time on Facebook and it has nothing to do with the phone.
No, that's relevant to Facebook.
All right. Throughout the night, there was an email from Uber, correct?
Correct.
What time was that email sent to?
So the email was sent and recorded on the email servers of Gmail in this case at 3:51 and 17 seconds.
And from Uber?
From Uber.
And where was the Uber ride?
So the Uber ride was from the previous night, and I will have to scroll past because I did the entire thing. The Uber ride was to 1200 West Canal Street.
Is that the Twisted Fisherman?
Correct.
So this email was just a bill, the receipt for the Uber ride,
Correct.
sent at what time?
I'd have to go back. At 3:51 and 17 seconds.
Were there images? There were a number of other social media notifications that you could see, correct?
Yeah, throughout the early morning, there's a bunch of Facebook notifications or Facebook newsfeed.
But again, the phone's off at that time? Okay. Did you notice what time there appeared to be user interaction with the phone again?
At 8:59 in the morning.
And sometime prior to that, obviously it gets connected to the power source. What time does it turn back on?
It turns back on at approximately 9:20 in the morning.
So the first human interaction you're discussing, that's the...
So between 9:19 and 9:20. So there's settings on your phone that when your phone dies or you turn it off, they're literally called persistent settings. These settings are so that all the settings you have on your phone, you don't have to go through your phone and reconfigure your phone. So these settings are some of the first ones to activate themselves upon your phone reactivating, and that reset of these settings occurs at approximately 9:19 and 54 seconds.
So the phone's back on by 9:20 a.m.
Correct.
After having been off since 1:35?
Correct.
Okay. Throughout the date of April 2nd, did you notice there were other interactions between this phone and images of Sade Robinson?
I did.
Tell us about that.
So on the 2nd, at 4:10 p.m. and 4:24 p.m., there were several cached images from Instagram of what appears to be Sade. And then, yeah.
How about April 3rd?
Again, on April 3rd, there are 2 photos cached of looking at the Instagram images or interaction with.
All right, let's move on to the computer tower. What did you notice on the computer tower beginning in that similar time frame shortly after midnight?
So shortly after midnight, there's a user on Netflix, and at approximately 12:07 and 38 seconds, they search within Netflix Love Death, which brings them to the Netflix show Love, Death, and Robots.
Whose computer is this again?
It was told me to be Maxwell Anderson's.
Okay. So the computer goes to Netflix at 12:07 and puts on a show, Love, Death, and Robots?
Correct.
And then tell us what you're able to see about what happens with Netflix and what you were able to determine is specific user interaction when that stops.
Sure. So from that period of time, the first show is queued up, and that is an episode called 3 Robots Exit Strategy. After this, the user several seconds later transitions to another episode called Bad Traveling. The show begins to play several seconds after that.
What time is this at?
That is at 12:07 and 50 seconds.
Okay, then what?
Then shortly after that show ends, the next episode begins to autoplay. This would be the episode, The Very Pulse of the Machine.
At what time?
That is at 12:08 and 12:08 and 16 seconds.
Okay. That was not user interaction, that was Netflix auto playing?
Yes.
Okay, then what?
Then around a dozen minutes after that episode begins, its credits transfer to the Night of the Mini Dead, which plays. It's just under 7 minutes. Again, I tested using the same browser and everything to check the properties of how Netflix worked at that time, and approximately when there is the time when Netflix starts to autoplay the next episode is when that episode starts to transition and beginning, which would be this Night of the Mini Dead.
Okay, and what time is that happening at?
And that is happening at 12:23 in the morning. And
Is that what I have on the screen here highlighted?
yes, that is correct.
So when's before 12:23, when is the previous last human interaction with Netflix?
Before 12:23 would be around that 12:07.
So from 12:07 to 12:23, Netflix is just playing on the computer, and then at 12:23, is there human interaction at 12:23 or no?
At 12:23, shortly thereafter, well, no, not at 12:23. Shortly after that, there is user interaction about 5 minutes after that.
At what time?
At 12:28 and 11 minutes.
And he puts on an episode of what?
An episode of Three Body Problem, which is a suggested show under Love, Death, and Robots.
And does the episode play?
So it sits on there, but the user transitions to that and then begins to play the first episode.
What time?
So it begins to play at 12:33.
So and then how long is that episode?
That episode's about an hour, I believe.
Is there any user interaction with the Netflix throughout the night after that time?
No.
With the computer tower at all?
No.
So just to recap for the computer, there's user interaction with Netflix at 12:07 a.m.
Correct.
That stops. Then shortly after 12:23, there's an additional user interaction at 12:28?
Correct.
And then after 12:28, is there any other user interaction?
No.
Any user interaction with the computer tower whatsoever between 12:45 a.m. and 8:43 a.m.?
No.
There's stuff going on in the background of the computer, though?
Correct.
Can you summarize that?
Yes. So, there's a lot of system activity with a computer that's tied to the internet. So just to name a few, there are what appear to be logins, but these logins are system only. So when you aren't using your computer, the computer is doing maintenance of itself. So it's logging in and out. There's different security IDs. So one of the ones that I have down here listed is it's a Windows event log 4625. And it's a type 5 service, which is again operating system only, not human interaction. What ties further is the Wi-Fi lease is up. So essentially at about, what time was that? About 2:35 a.m. in the morning, the internal IP address for the computer itself's Wi-Fi lease expires. So what this essentially means is there's different types of networks. You have your internal network, then you have your external network, internet, and all of that stuff. In the internal network, in all networks, there's a finite amount of IP addresses. So what your router does is it cycles through these things, and your router has basically this dynamic host inside of it that reassigns things IP addresses. And the reason you need an IP address is it's essentially, if you think of your house or your apartment, it's that number on there so that the traffic knows where to go. So at about 12 or 2:35 in the morning, the lease expires. It appears that this the router for this was only set up to have about an hour period, which is fairly short, which causes interruptions with like streaming and things like that, which would be the reason why Netflix stops at that exact time, because it can't reach out to Netflix because it doesn't have an IP address for a millisecond or two to pull the next episode.
So when the episode is started at 12:28 a.m., well, first of all, are you aware if Netflix will just continue to play the next episode?
Yeah, Netflix plays 3 episodes on average, unless you change the settings, but it will auto play 3 episodes and then do the whole "Are you still there?" kind of thing.
Is that what was happening here?
Correct.
Okay. No further user interaction with the computer after 12:28.
Correct.
Just a couple clarifications. I actually want to touch on one thing. When we looked at those, when we looked at some of those cached images from the phone, a lot of those it's like a created date that says January 1st, 1970.
Correct.
Can you tell the jury what that's about?
So in computing, computers obviously don't understand time, so they need a time frame from which to start. So there's different things that in computing is called epochs. So they pick a specific time in history that creates essentially a calculation from how far from that date we are currently now. So when there are no actual dates, it will revert back to that epoch time. So, and off the top of my head, I couldn't tell you which type of epoch it is, but I believe it's potentially the Unix epoch time of 1/1/1970, which essentially means there's no date.
It's just kind of a default.
It's a default, correct.
I have no other questions.
I think we'd like to start after lunch if we could.
I think that's fair. It's 10 minutes to noon, so we will take a break at this point. Remember the admonitions. Remember, no communication between each other about this case, no discussion with family or friends, no posting, no emailing, no texting about anything to do with this trial. Wear your juror badges prominently. Don't do any investigation. Put it completely out of your mind till you come back this afternoon. This afternoon, we can kick up at 1:30.
1:30, Judge.
1:30. So we'll have the door open before that. Hopefully you'll all be back on time so that we can get started right at 1:30. Okay, thanks everybody. Just leave your notebooks on your seat.
Is in its final handful of witnesses, and we'll start after lunch with cross-examination of the digital forensics expert from the Department of Justice Division of Criminal Investigation, who's been talking about some of the devices, including Maxwell Anderson's phone and a computer in Maxwell Anderson's
Is there anything
home.
to address on the record before we break?
I would just, for purposes of planning, inform the court that I only have one more witness.
Okay.
Great, we'll be ready to go.
Okay. We'll see you back at 1:30. Thank you, everybody.
Okay, so there you have it. One more witness to go from the state. Of course, that is after the defense is finished with cross-examination of the current witness, Jason Ruff from the Division of Criminal Investigation, a digital forensic investigator. Again, he's been talking about Maxwell Anderson's cell phone and a computer in Maxwell Anderson's home, going through sort of a timeline of when it was receiving, each of those devices were receiving human interaction, what was happening on them, and then when they stopped having human interaction. The state is clearly demonstrating with this testimony, or attempting to demonstrate, that this matches the timeline they've given, that Maxwell Anderson left his phone at home while they say he was driving Sade Robinson's car all around the city and ultimately disposing of her body parts and setting her car on fire before riding a Milwaukee County Transit bus back home from the north side. What we did hear from there toward the end of that testimony was, or the latter part of that testimony was, actions that the forensic investigator says occurred on Maxwell Anderson's phone shortly before the last human interaction with that phone, and that is that a batch of photos were deleted from that phone. We've actually heard a couple of witnesses who have talked about the deletion of photos and the photos that were ultimately recovered from that phone, the photos that had been modified or deleted by the user. That those dozens of images were reportedly deleted around between 12:05 and 12:08 a.m. And the last human interaction with Maxwell Anderson's phone occurred at 12:09 a.m. when the phone went into sleep mode and had no additional human interaction until 8:58 the next morning. Among the images that were deleted, we do know, and we haven't seen them yet because they involve the exposed breast of Sade Robinson, but we are, as it was described, they are photos of her face down on a red couch with a brown piece of furniture nearby, which seems to match the description in the photographs we've seen of that couch in Maxwell Anderson's living room with the large dark brown ottoman next door to it. There are clothing identifiers in those photos that seem to match, as they've been described by the witnesses, that match the photos we've seen earlier in the trial of Sade Robinson's clothing. Sade Robinson's ripped jeans, the light-colored jeans, and also the white cable-knit sweater. Also a description of the underwear that was recovered from her burned-out car, the trunk which was not itself burned. Those jeans and underwear match what was described by witnesses in those photographs from the phone. One other really important thing, though, that came from the testimony about the cell phone, the photos on the phone, is there was apparently a screenshot of a website or something, how not to, or what not to mix with bleach. That was one of the exhibits, one of the things that investigators say they found had been deleted from the phone. And I'm going to go back and make sure I'm saying that properly, but it was a screenshot of what not to mix with bleach, which had been modified, that's the term that they officially use, apparently deleted, at 11:28 p.m. on April 1st. So that would have been during the time frame that Maxwell Anderson and Sade Robinson were allegedly in his home, and about maybe, a half hour before the last interaction with his phone, before he deleted the images that were ultimately recovered. So what was he doing, looking at something or taking a screenshot of something that said what not to mix with bleach? Well, the suggestion there is he was planning to do some extensive cleanup of whatever had occurred there at the home. That seems to be, anyway, where the state's going with this. Obviously, we'll hear their theory and closing arguments as to what they believe this means. We've been looking all along, waiting for the state to offer up a theory of when and where the homicide itself took place, when and where the dismemberment took place. They have certainly gone a long way to demonstrate the timeline of when and where Maxwell Anderson was, when and where Sade Robinson was, the connections between the two of them at his home, and these photographs seem to place Sade Robinson on his couch during the time when prosecutors all along have been saying that the two of them were in his home. To some degree, it also seems it may make the downstairs neighbor's testimony less relevant, which is he's the one who said, I didn't hear anything. I didn't hear anything going on up there. I didn't even hear anybody up there. Well, now it appears the state has given some pretty strong evidence that, in fact, they were upstairs. Now, whether or not there was a murder taking place at that time, we don't know. but it does appear that she was there and she was on the couch based on the photos. Again, we haven't seen them ourselves. We know how witnesses have described them. I will tell you, our news managers here at Fox 6 News have seen those photos. They are going through those photos in detail right now and trying to see if we can blur and crop them in a way that we can show you the pertinent parts, because these are key pieces of evidence. These are crucial exhibits in this case. What we can sensitively show you once that process is through, and once we have editors who have properly addressed those exhibits, the raw exhibits. We're not going to show those raw exhibits on the air. We're just not going to do it streaming or on our broadcast. But we are going to be able to show you those images so you can see for yourself. They are currently working on that. I know that's in both the managers and editors' hands right now. Once we have them, I'm hoping we can bring them here to you for the first time on here from the Wisconsin Live Desk. So that is kind of where we are right now. We want to get to those photos. So far today, and by the way, you just heard, if you're just joining us, we just heard right before the lunch break that the prosecution informed the judge they have one witness left. We have now heard from 82 witnesses in this case, and we will hear from an 83rd. We don't know yet who that's going to be. But the 82nd witness is still on the stand. Defense will begin its cross-examination of Jason Ruff, the digital forensic investigator for the Division of Criminal Investigation, after the lunch break at 1:45. It sounds, because of that, then, like we should expect that the state is going to rest its case before the end of the day today, and then the defense will get to present its case. We don't know what the defense will have left, how many witnesses they plan to call. A lot of the defense's case has already been made through cross-examination. We know Tony Cotton and Jason Findling have been very thorough in their cross-examination of witnesses, and they have tried very hard to poke holes in the state's case and raise attention to the things the state just doesn't have: a murder weapon, a bloody crime scene, things like that, direct evidence of a homicide. So we don't know how much more the defense will have after that last state witness. But once the defense is finished, the next step in the process will be jury instructions. And for that, the jury will not be in the room, but there will be some back and forth as the parties work with the judge on what should go in those jury instructions, how certain things should be worded. There will be some sort of back and forth over that. And once jury instructions are complete, then there will be a period of time where the judge lays out those instructions, and that will take significant time. They will go through those instructions for each of the counts that Maxwell Anderson is charged with, point by point, what the jury must find to find him guilty. And finally, after all of that, the jury will go into that room. They will next they will select the 12 jurors out of the 15 who've been listening to this entire case, who will go into that deliberation room and ultimately decide Maxwell Anderson's fate. And then they deliberate. And then it's jury watch, it's verdict watch. And at that point, we'll be watching closely and being prepared to bring you the ultimate verdict. To set expectations, I don't know that this is going to happen by tomorrow. I have a sense that this is going to take enough time. We're going to be going into early next week. I don't know that for sure. I'm making my own educated guess here. We'll be talking a little bit later on to Jonathan Lavoie of Kim and Lavoie. We've heard from Julius Kim all week long. Now we're going to have his law partner, Jonathan Lavoie, at about 12:40 today to talk about his impressions of the testimony today and what's left. Maybe he'll have some thoughts on what the defense still needs to do, or what we might hear from on the defense, and maybe he'll have some idea of what we should expect in terms of our remaining timeline. But again, that's coming up at 12:40. We are also going to hear in a short while, not sure quite when, but we're going to hear from Fox 6 reporter Stephanie Quirk, who is at the Milwaukee County Safety Building today. I'm not sure if she's been in the courtroom listening to the testimony or if she's been outside all day watching it along with us, but we will get some sense from her of the feel outside the courthouse or outside the courthouse and outside the safety building. Are there supporters down there today? Kind of what's the atmosphere? What is she seeing? We'll talk to her coming up here shortly. And of course, we will return back to the courtroom after the lunch recess, which will probably take place somewhere in the neighborhood of 1:45. I didn't hear if they said 1:30 or 1:45, Delaney. I don't know if you caught that. But typically every day it's been closer to 1:45. 1:45 anyway before they get back on the bench. So you see the clock there on the left. That's the shot that indicates they are currently at break. It's going to be a while then before they resume, but we've got a lot to talk about. And I've been telling you about the digital forensic investigator. Let's go back to how the day started because, and I was looking at my witness list. I told you there's 82 state witnesses who've testified. Many of them are people who've been recalled multiple times. So I'm not necessarily it's 82 distinct individuals, but of the 82 appearances on the stand so far, and some of them are continuations over a break from the morning to the afternoon. But of those 82 people, 62 of them are members of law enforcement, primarily the Milwaukee Police Department and Milwaukee County Sheriff's Office, a few from the State Crime Lab and places like that. 12 civilians in all have been called so far, and let's see if I can tell you who all of those civilians have been to this point. We heard originally from Osiris Terrell. That was one of the men who found Sade Robinson's leg in Warnemount Park back on April 2nd of 2024 in the afternoon that day. We heard from Christine Shuda, who's a leasing agent at Sade Robinson's apartment at the Brewers Point Apartments there on the Lower East Side. She talked about her impressions of Sade Robinson and also of the expectation she was about to go out on this first date with Maxwell Anderson. Eddie Feliciano, building maintenance for Sade Robinson's apartment building, said that he had known her for 8 months. She was very kind, and also he said that she seemed to be excited to be going out on this date. We heard from Angela Young, who was a co-worker at Pizza Shuttle of Sade Robinson. She reported Robinson missing the evening of April 2nd after she hadn't shown up for work, which was very uncharacteristic, she said, and after seeing that through her Life 360 app that her cell phone appeared to have died and was somewhere on the south side near Warnemount Park in Cudahy. So she went to police to report her missing. We heard from Elena Fisher, who also had tracked her friend's movements, Sade Robinson's movements, through Life 360 and became concerned when she stopped responding or when her phone stopped moving and she wasn't responding. We heard from Evelyn Gertz, who was another co-worker, had at one time worked with her at the Wisconsin Club as a server, said she was a very kind person. We heard from Angela Sawyer. She's the one who found Sade Robinson's torso and arm having washed up in South Milwaukee along the shores of Lake Michigan. That was several days after the discovery of Sade Robinson's leg. We heard from Russell Davis, the owner of Twisted Fisherman, who had actually employed Maxwell Anderson for a few weeks in 2023. We heard from Pete Warbington, one of the big witnesses in this case, who was the downstairs neighbor, Maxwell Anderson's tenant, who said he did hear a suitcase coming down the stairs at around 5-something in the morning, on the morning in question. But he said he did not hear any kind of a struggle, any screaming, any power tools, or anything that indicated there was some sort of a bloody murder happening upstairs. And he said he was a light sleeper and could hear just about everything. Lemitra Griffin, the security worker at Dukes on Water, testified that Maxwell Anderson was a regular there. He recognized him. Tim Sluga, the new owner of Dukes on Water, on the date this happened, said Anderson was a regular and they had actually seen each other at the bar that day. And finally today, I'm not going to use her name, even though it was given on the stream earlier, but ex-girlfriend of Max Anderson, victim witness coordinator, asked that her identity not be highlighted. So the ex-girlfriend of Maxwell Anderson testified today, and that's what I want to talk about now, because that was a big witness here on day 8 of the trial. This ex-girlfriend had dated Maxwell Anderson back in 2023. And when she heard about what had happened on the news, the leg that was found, her ex-boyfriend being arrested, she reached out to authorities to say, I've got some information you might want to know about. And one of the things she told them was, I don't know if you've searched the house yet, but inside that house, he's got some secret compartments. In the bathroom, under the vanity, there was some sort of a secret compartment where he apparently kept weed and cash. And he had some other places in the house where he had sort of disguised things in a way that, the average person wouldn't be able to tell there was some sort of a secret compartment behind it. The significance of that, we can only guess. One would be to demonstrate her familiarity with his home and her familiarity with Maxwell Anderson. Potentially also to demonstrate he was the kind of person who concealed things from others, who was not above trying to hide things from others. That's my speculation. I don't know if that's where the state's going with it, but they presented that. She also told them about something that the state spent a lot of time talking about, a phrase they used over and over again. She said Maxwell Anderson had taken her to a secluded beach along the Milwaukee lakefront. She wasn't able to say exactly where it was, but she led police there because she remembered the landmarks. She knew how to get there. She said he called it there, or his secret beach, and he didn't want her to tell anyone about it. He even said if they ever break up, he didn't want her to take somebody else to this place because it was his secret beach. Well, she led investigators directly to the spot where she says those secret beach appearances were that he took her to. They were there 5 to 10 times. You might recognize this. This is the service road that prosecutors say Maxwell Anderson drove down in Sade Robinson's car before he deposited her body parts into Lake Michigan. Well, that's the road that this ex-girlfriend took investigators down and said this was the route we took to get down to the beach. There are other photographs of where she actually met with Anderson, where they would set up camp. They would have campfires. He would bring his dogs. She described in detail exactly where there was a downed tree, and they would use the dead wood to make their fires. And there was a picture she provided them of Maxwell Anderson's dogs at the beach that was from that very spot. And a detective on the stand said that location was in fact the very location where Sade Robinson's leg was later found. Again, she said she had been there with him 5 to 10 times, and that this was a secluded area that they rarely saw anybody else. They didn't hang out with other people. It was just the two of them. Occasionally, maybe a dog walker would come by, but she said it was generally very secluded, not easy to access, and he considered it their, quote, secret beach. On cross-examination, the defense asked, okay, you went there all of these times, but was he threatening? Was he physically abusive? And she said no. After that question, the state asked for a sidebar. They said, Judge, we want to ask about something. And then the judge ultimately sent the jury out of the room, and there was some discussion about whether the defense had opened the door to character evidence. By asking the question, did he physically abuse you? The state argued that they had given the indication or implication to the jury that he was peaceful and not a violent person, because she answered, of course, no, she had not been physically abused by him. But the state says there was, and the defense was aware, there was also indication in her interview with law enforcement that he had been emotionally abusive with her, that he had been cruel, he had called her names that were sexually derogatory, and that in fact he had also been involved in a couple of violent incidents. One, or at least one, which was a fight at Trinity Bar in Milwaukee with that woman's ex-boyfriend, and also that at one time he had apparently tried to conspire with her to set up the ex-boyfriend by telling her she should beat herself up in the bathroom and then contact police and say the ex-boyfriend did it. She never did that, but that was included in a police report. And the state said, look, they've brought up the fact that he didn't abuse her physically. They've given the impression to the jury there's a character trait that he's not a violent person. We think this other evidence is now fair game. The judge ultimately ruled that some of that was fair game. The fight was a violent act. The setup of the potential setup saying you should beat yourself up in the bathroom was potentially connected enough to violence that she allowed the state to ask about it. She didn't allow them to go into detail about the emotional abuse or verbal abuse. So when the state got back on the stand, when the jury was back in the room, the prosecution brought up the fight, that there had been this tussle at Trinity nightclub with the ex-boyfriend. They said nothing at all. They didn't ask any questions about his pressuring her or instructing her to beat herself up to set up the ex-boyfriend. The judge had allowed it. They didn't go there. After that happened, I did get a text message from Julius Kim, who is, of course, the expert we've been relying on all week to, one of the experts anyway, we've been relying on all week to give us some insight from the mind of a criminal defense attorney and a former state prosecutor. So why didn't the state go there? And he believes it's because the state is being careful in protecting their record. He said less experienced prosecutors might have really gone full bore after his character, But by going too far, they might have, in fact, opened the door for some sort of an appeal. So to protect the record, they were conservative about it. He thought that demonstrated experience and a smart move by the prosecution. He said lesser experienced prosecutors may have really gone full bore after that. They didn't. But that was an interesting moment from this morning. I think probably the key from that really was discussion of Maxwell Anderson having taken a previous girlfriend to a quote-unquote secret beach, which turned out to be the Warnermont Park beach where Sade Robinson's leg would ultimately be found. After that, we did hear from Milwaukee County Sheriff's Detective Mason Colehap. And Mason Colehap was the detective who did the cell phone extraction, or reviewed the cell phone extraction of Maxwell Anderson's phone. We've been talking all week and for the last really 8 days, as we keep hearing more. Since opening statements, we've been hearing about photographs found on Maxwell Anderson's phone. Photographs that place Sade Robinson in his house on the night in question, and in fact on his couch. So we've known that was coming. Finally today on day 8, those photographs were shown. But first, Mason Colehap, the detective, was asked to talk about what else was on that phone, particularly a more extended conversation through text messages. We already knew the sort of short conversation right before they met at Twisted Fisherman, where Maxwell Anderson and Sade Robinson are talking back and forth. You know, where do you want to meet? She says, are we going to the Broad House? He says, how about Twisted Fisherman? I'm feeling seafood. She says, I love seafood. See you there. And they meet up. Well, now we got a little more, a little bigger picture about their communications. All along, this has been described as a first date, and it seems it still might have been, but it was not the first time Max Anderson and Sade Robinson had met. In fact, according to the text messages that Detective Colehap went through, they had been at Victor's nightclub together a few nights earlier. And in fact, at that time, after they had been there, I believe Maxwell Anderson must have borrowed a comb or something. I didn't catch all of it because I was multitasking. But one of the text messages is, hey, I'm going to need my comb back. Can I get that back from you? And he says, sure, I'll bring it tomorrow when we meet up again. So they had clearly made plans to meet again. They were supposed to meet on Sunday. Sade Robinson missed his message, and then later, while she's at work that afternoon, says, sorry, I'm at work just seeing this, you know, I don't know how long I'll be here till. He says, okay, sounds good. Want to shoot for another night instead? She says, yes, I can do today or tomorrow. He says, either works for me, whichever you prefer. And this is now on April 1st. Okay, we can do today. What time? He says, anytime is fine for me. She says, Broad House or the other place, and now we're into the text messages we know all about. So we knew up until just got to Twisted. Okay, are you inside? Yes. And then they appear together inside Twisted Fisherman. There was one more text message between the two of them, and it was on Maxwell Anderson's phone on April 2nd at 10:36 in the morning. And it said, morning, how is work going? Sent from Anderson to Robinson. No response from Robinson. We know by that time it's many hours after her car has already been found burned on the north side, intentionally set on fire. And there's those images of Maxwell Anderson walking away from that car. So about 7:30 in the morning, we've got this surveillance video, all these shots we've been showing you over and over of Anderson, or what clearly appears to be Anderson, walking away from the scene of the car fire, walking a few blocks, getting on a bus and riding that bus back home to the south side. And then 3 hours after, well, he gets home at like 8:42 in the morning, right? 2 hours after that, he sends a text message to Sade Robinson. So the guy who was just walking away from her burned out car then sends a text message, morning, how is work going? Obviously, the prosecution is looking to make the point here that he was trying to set up that I didn't know what was going on. Look, I texted her, how's your morning going? I assumed she was fine. Can't prove that that is or isn't the case, but it certainly stands out when you look at the other evidence that's been presented so far. And then, of course, we start getting into the photos. Now, as I mentioned earlier, we haven't shown you those photos yet. You didn't see them on the live stream because they are very sensitive. We know that at least 2 of the photos include part or a full view of Sade Robinson's exposed right breast. breast. It is, if I recall correctly, it was her right breast that was cut off of her body. One of the things that prosecutors have talked about in terms of the dismemberment, we know that the legs were removed from the torso. We know that the arms were removed from the torso. The head has never been found, but specifically one of her breasts was cut off. I believe it was the one that we haven't seen, but it has been described as being in the photograph. Those photographs they were described as there being a hand grabbing what appears to be the breast. There was a photograph of pants and underwear that had been removed, exposing her buttocks, and that there was a description of her being face down, that there's a white cabled-knit sweater, and we've talked about that sweater. I can show you that again. This is the sweater Sade Robinson was wearing at Duke's on Water on the date on April 1st. And prosecutors zoomed in on this here and pointed out, if you look at that right sleeve, you see the cable knit pattern of that sweater. Of course, you can see her dark hair and she has a darker skin tone. As it's been described in the photo that I haven't seen, that you haven't seen, but that was placed into evidence and was put up in front of the jury, in front of the gallery, there's a person laying face down on what is a red couch, apparently with a brown ottoman next to it. And that person is wearing, or there is a sweater that is visible that we hope to be able to show you with a blurred photo later on that doesn't show anything overly sensitive, but you'll be able to see that it is the same cable knit sweater in the photo from Maxwell Anderson's phone. This is why prosecutors spent time looking at that. The other thing they're going to talk about, and that you'll see in these photographs, these are the jeans. You see the light color, the rips in those jeans. It was 7:30 in the morning on April 2nd when these blue jeans, light colored with the rips in front, and you see the underwear around the outside, that sort of yellow colored bikini underwear around the outside. This is what was recovered from the back trunk of her car. And detectives who talked about this said they were recovered in this way. They weren't placed like this. They were on the outside. The detective at the time was asked, what does that suggest? And she said it was consistent with those items of clothing being removed by someone else as they pull them down. And they were removed by another person. That's how they ended up in that position. One of the photographs shown to the jury purportedly shows the jeans and this very distinctive colored underwear in that photo. We're not going to be able to show you that one because apparently in the way that one is arranged, it's her exposed buttocks and there's just no sensitive way for you to see that. But we do have some of the images.
Every TV show I watch show buttocks. Every TV show I watch show breasts. Network TV. So now we in the middle of a trial and y'all sensitive? No, we want to see the fucking evidence. That's why we watch trials on fucking TV, because we want to see the goddamn evidence. Now show it to us.
Images being worked on right now that we're going to hopefully be able to show you a little bit later on that will, because they're key. These are key pieces of evidence in this case that place Sade Robinson, according to the state, in that apartment on the night in question. First, were you in the safety building this morning or have you been outside?
So I was actually in the safety building in the courtroom for the first time throughout this experience. Last week I was watching the live stream that's been going on outside of the safety building and just kind of giving live updates. But this was my first time actually inside the courtroom today. Brian. Tell
me about what you saw in terms of who is there and what you know. These are some tough things that were shown, especially those images of what is purportedly Sade Robinson on Maxwell Anderson's couch. Can you talk at all about what you saw in terms of family or people in the gallery or even the jury? What kind of responses were they giving?
Yeah, actually when they started going through those photos and when the detective was testifying about those photos and those text exchange, Robinson's family actually had to leave. She was, her mother was seen being walked out of the courtroom with the victim services official as well as other family members and just kind of, you could feel that today, this evidence obviously being shown, it weighed heavy on them, not only the family and loved ones of Robinson, but the entire courtroom. In fact, we heard some members of the jury were actually tearing up.
We haven't seen those photos because they weren't shown on the live stream. You're in the courtroom and could see them. I imagine you've also seen the photographs of things like Maxwell Anderson's living room, the red couch, the brown ottoman. After seeing them for yourself, does it appear that it's convincingly, I mean, just to you, that, yep, that's the same place? Because we haven't seen it. We're kind of having to rely on the description of those witnesses. From your observation, could you look at that and go, yeah, that sure looks like the same place?
So they did almost like a back and forth between the photos of Anderson's couch as well, and then those photos that they showed as evidence that the detective testified were taken off Anderson's phone, and they were distinctive because basically he has a red couch and there's almost like a blue pillow on there, and in one of the photos you could see that it appeared a woman was laying face down on that red couch, and you could see in the corner of the photo that blue pillow that's the same color. And when they showed the back and forth, it did appear very, very similar, just to my eyes at least.
So, not having seen it, I saw someone describing on, you never know what you're going to read on social media, but I saw someone describing on X that they just showed photos of Sade Robinson passed out on the couch. Is it clear from the photos that she is conscious or unconscious? Can you tell? I don't know if that was testified to. I didn't catch that. Was she, can you tell if she's awake or not, or conscious? What did it look like?
The detective actually did testify. It's unclear whether or not she was conscious, whether she was sleeping, whether she was unconscious, or potentially whether she was dead at that point those photos were taken. But you could see she was face down on the couch there. So even the detective said it's unclear as to, what her state was at that point.
So I'm back here all the time, Stephanie, juggling. Many of us, we're juggling multiple things. So you're trying to listen to every word of testimony, but you get called away for something else. And as they're going through all of those photos, I initially missed a really key one until it was actually Julius Kim who texted me and told me about this. And then I went back and looked and saw, sure enough, in Bill Miston's notes, there it was. There was a screenshot that detectives say was on Maxwell Anderson's phone that was one of the images deleted. That screenshot really seems like kind of, I don't know if it's the smoking gun, but it sure doesn't look really good. Can you tell us what that screenshot said?
Yeah, that was very notable. Throughout the entire morning, that was one thing that I was like, whoa, okay, while taking my notes. So it was a screenshot basically of a screen grab or a download of what not to mix with bleach. And this was taken, if I go back to my notes, it was a screenshot that was taken, that the detective testified was taken from Anderson's phone, apparently a search or something of what not to mix with bleach. So
and if I saw correctly,
photos,
Stephanie, it was taken, or it was modified, which I think it was deleted. That screenshot was deleted at 11:28 p.m. that night, which is about maybe a little more than an hour before they leave. So is he still looking at, like, how do I clean this up before we go? That seems to suggest that he had about another hour and 15 minutes before the car leaves to do whatever he was learning through these searches, right?
Yeah, and it was actually very interesting. The last witness that was called to the stand before lunch break here was a forensic analyst. So basically his job is to analyze the cell phone data and the times, and he was walking us through a timeline basically of whether or not there was human interaction on Anderson's phone and a timeline of that. So he kind of walked us through that. He said at around 12:08, if I'm correct, the phone, that was the last time the phone was used, but prior to that, he testified that data revealed that whoever was using the phone at that point was using the camera app and going back and forth between the camera app to take photos, or it appeared, and then following that, Anderson's computer was used actually. That forensic analyst testified that basically he put on a show around like 12:08, and then put on a different show throughout that time. And if I have my timeline correct, it was around, I want to say 12:35. That was the last time there was any human interaction with the computer.
You're correct. It was 12:33. It says that he started playing a show called Three Body Problem, which is an hour-long show. but that was the last human interaction that they detected. And of course, Netflix will continue playing things for a few episodes and eventually say, "Are you sure you want to keep watching?" And then it stops. But at 12:33, that would still be consistent with the state's timeline. That if they left at 12:45, he starts an hour-long show a couple, 10 minutes or so before they leave, and then just lets it keep running.
Yeah, absolutely. And another interesting thing, too, I don't know if you mentioned this earlier, but the state did announce prior to lunch break that they have one more witness to call to the stand today. So this will it'll be interesting to see the pivot, obviously, before Friday. The trial was anticipated to last up to 2 weeks, and it went fast, but it's kind of crazy to think that we're nearing a pivot now to hear the defense's side of the argument and just kind of how this all plays out.
We've got about 30 seconds left before I got to take a step away for a minute, but let me ask this. What was it when they said one witness left? Did you hear any reactions in the courtroom? Because I've got to imagine this has been a marathon.
Yeah, absolutely. Everybody kind of looked at each other like, okay. And honestly, I keep forgetting it's Thursday, but tomorrow's Friday. And as I mentioned, the judge anticipated the trial would last up to 2 weeks. I believe the defense is calling expected to call roughly 6 witnesses to the stand. So it'll be interesting to see.
All right, Stephanie, we've got to step away. Thank you very much. We're going to have you back in just a little while, but I appreciate you being here right now. And we're going to take a break. We'll be back, step away, and be back in just a couple of minutes.
Thanks, Brian.
This is the Wisconsin Live Desk.
And I am Fox 6 investigator Brian Polson here on day 8 of the Maxwell Anderson trial. It's been a long 7 days of testimony, but we're getting near the end. It is, we understand there is one more state witness to go after the defense finishes its cross-examination or gets through its cross-examination of the current witness. So one more to go. And then we just heard from Fox 6's Stephanie Quirk that the defense plans to call maybe 5 or 6 witnesses. So I doubt we'll get through them today, but it does certainly sound like the state is going to rest probably this afternoon, and the defense may get through its witnesses tomorrow, which means we'll get into the part of jury instructions sometime tomorrow. I don't know if they're going to get to the point of actually, if they're going to get to the point of actually giving the jury the case to go into deliberations before the end of tomorrow, but certainly we're getting to kind of the last bits of all of this. Again, it is 12:30 right now. If I can get the right thing pulled up here, just you can see that the court is in recess. It's 12:33 on their clock. They plan to come back at 1:30 this afternoon. Somewhere around 1:30, 1:45 will actually be on the record and ready to go. What we have coming up in about 10 minutes, we're going to hear from Jonathan Lavoie of Kim and Lavoie, a criminal defense attorney who is going to give us his thoughts on the new testimony that's been shared today. And then we'll also have Stephanie Quirk back here probably around 1 o'clock. And we're going to give you a walkthrough of everything we know. We still don't have the images to show you yet. The images that were shown today of Sade Robinson purportedly on Maxwell Anderson's couch. We're not going to show you the raw, unedited exhibits because there's some real sensitive stuff there, including Sade Robinson's exposed breast in at least 2 of them. However, we do have editors who are working on getting us images we can show you that will give you some idea of what you're looking at without showing things that are a bit too sensitive. So we want you to be able to see these key exhibits. Those are still being worked on right now. And so we'll get to that in just a little bit. I want to walk you through what we have heard so far today. And there have been 4 witnesses so far today, 1 civilian, 3 from law enforcement. We started the day with a witness who had specific information about Maxwell Anderson himself because she was Maxwell Anderson's ex-girlfriend. Now, her name was given out. It went over the live stream. There was no editing of it or anything like that. Judge Crivello said she was notified during her testimony that this witness's name had been left off the list of witnesses whose identities were not to be revealed during the live stream. And at that point, it had already been stated, so she let it go. That said, we are aware that a victim witness coordinator has asked that the media be sensitive about the use of her identity, so we're not going to give her name here, even though it's out there in the public domain. There's no reason to add to that. The importance is she was Maxwell Anderson's ex-girlfriend. They had dated and broken up at some point in 2023. There were 2 key things that she testified to. The first of which is she said after she heard about Sade Robinson's leg being discovered along the bluff at Warnemont Park and that Maxwell Anderson had been arrested for Sade Robinson's death and dismemberment, she reached out to law enforcement proactively and said, I don't know if you've searched his house, but here's something you might want to know. He's got some secret compartments in that house. One of those secret compartments she described was in the bathroom under a vanity or inside a vanity, something that was someone else wouldn't be able to tell was there. But that secret compartment inside the vanity was a place he might keep cash or weed, things like that. So she told them about that. And she said there was also, I think, another compartment in the living room perhaps, but other places in the house there were these sort of secret compartments that were disguised in a way that a typical observer wouldn't know they were there. Now, there was no indication that there was anything nefarious found in these secret compartments. However, she testified to that. It kind of maybe raises the question, is this the kind of person who has a habit of concealing things from others? I don't know if that was the intention, or if the purpose was to demonstrate her direct knowledge of Maxwell Anderson to the point of knowing he's got these secret places in his home. Because secret is a really key word here. The next thing she talked about was a place Maxwell Anderson took her to 5 or 10 times that he referred to as, she said, his secret beach. And she didn't know at first exactly what that beach was called. She learned later from all the news stories it was the beach there in Warnemont Park. So you might say, oh, well, she knew that because of the news. Well, investigators said, take us there. Show us how you get there. And they took her on a car ride, and she used landmarks, including a Mexican restaurant along Layton Avenue, to say we would stop here on the way, we would have drinks and food, and then we would turn here, and we would turn there, and eventually they ended up at the fence at the front of the service road that leads down to Warnemont Park where Sade Robinson's leg was found. That fence says, do not enter. She described how they would squeeze between that fence, walk down the service road, and make their way down to the beach. I know we've got some pictures of that area. Here's the service road itself. I think actually, Delaney, there's one a little bit before that that shows the fence kind of a little further down the road. I know I saw that at some point. Is it? No, that's not it. That's just another view of walking down that service road. I thought I saw it in there somewhere, but I know they're kind of scattered here. In any case, that's the road where there was the fence that Sade Robinson's car busted through at whatever time that was, 3 o'clock in the morning on April 2nd. Same service road. Well, she's saying we used to squeeze through that fence and go down this service road on our way down to the lakefront. And she talked about specifically, I think there's a shot in there. Do you have the one, Delaney, that's got the pump house? There's so there it is. You see there on the right, that's the Cudahy Water Department pump house that we've heard so much about. The leg was found in the area of that, or nearby that pump house. So they go down here, and she even described to investigators how there was a rocky area down at the bottom that Maxwell liked to take the dogs over and go because it was a more direct route to the place they would set up camp. But she would take a trail off to the right because she would be wearing flip-flops or sandals and didn't want to cut her feet on the rock. So very specific to this location. And then she talked about getting down to the beach and even saying there was an area with like a tree that had fallen. There was some dead wood there, and that's where they would typically set up camp. They would set up and then use the dead wood to create their fire. He would bring his dogs down. She testified that he would say over and over again, you know, don't tell anybody else about this place. And if we ever break up, you know, I don't want you bringing somebody else here. This is my place. That obviously establishes a couple of things. Number one, it shows that Maxwell Anderson has been to the site before where Sade Robinson's leg was discovered, and that in fact he would take romantic partners to that location, and that he felt it was secluded and private and that other people wouldn't know about it. That certainly is what the state is getting at. Now, in cross-examination, the defense said, okay, so he took you there 5 or 10 times. That's been well over, you know, a year, now a couple of years ago, but before the incident, it's well over a year. Was he ever violent? Did he ever do anything, you know, that was physically violent with you? And she answered no. She hesitated, then she answered no. The state called for a sidebar with the judge. That means we want to discuss something out of the jury's ears. And the judge very quickly said, okay, let's send the jury out of the room. And we're going to talk about this on the record. When defense attorney Tony Cotton asked the question, was Maxwell Anderson ever physically violent with you? The state says he opened the door to otherwise impermissible character evidence, that they had raised a question that planted in the jury's mind by asking that question that Maxwell Anderson is peaceful and doesn't have any sort of propensity for violence. The state said that opens the door to talk about some things they had agreed not to talk about, but now they wanted to bring up, and that is that Maxwell Anderson had in fact been in a fight with his ex-girlfriend's ex-boyfriend, so the boyfriend before Max, that they'd been in a fight at a bar in Milwaukee, Trinity Bar. So, and there was actually some other indication that he had been emotionally abusive. And one of the things he had apparently done at one point was tell her she should beat herself up and call the police and say that her ex-boyfriend did it to set him up. Now, she never did that, but that was in a police report. She told investigators about his suggestion that she physically beat herself up and set up the ex-boyfriend with police. The judge said they could introduce that piece, but the state didn't. They didn't ask about that. And I did talk to Julius Kim earlier, who told us he felt that was actually a smart move by the prosecution not to go too far with that, to protect the record and prevent themselves from opening a door on appeal. Jonathan is up. Okay, so I've got to get him set up. We're going to have Jonathan Lavoie, who is joining us from Kim and Lavoie. And see if I've got things set up in the right place. I think I do. So let me just change up the sourcing I have here, and I think I see Jonathan right now. Let's get his audio going, and we are going to welcome Jonathan Lavoie of Kim and Lavoie, criminal defense attorney. Jonathan, thank you for being here at the Wisconsin Live Desk. Appreciate your time.
Of course.
So I don't know if you've been able to watch all the testimony today, but I know you've obviously been paying attention to the case throughout. And today we've seen some pretty critical testimony, both from the ex-girlfriend and then also forensic evidence coming from Maxwell Anderson's cell phone. What has stood out to you so far in today's testimony?
So today was kind of that bombshell day that we were waiting for. A lot of the key pieces of evidence that the state held back was presented today. And I think the girlfriend testimony, the ex-girlfriend testimony was significant. It talks about the exact area where, at this beach, where the body parts were found, that Mr. Anderson's familiar with it. He's been there before, and I think it ties Mr. Anderson to that location, and the state will argue logically that he disposed of a body in a place that he was familiar with. So I think that was a big start for the state today.
There's also that with the digital evidence, the cell phone evidence, the pictures in particular that we've been waiting for. You haven't seen them, and I haven't seen them. I do know that our managers are working on getting us, and our editors are working on getting us images that we can use that are sort of safe to show, that are sensitive enough to show, because we know these are very sensitive photos. They show purportedly Sade Robinson face down on Maxwell Anderson's distinctive red couch with the brown ottoman nearby. But then in a couple of these photos, her breast or her buttocks are exposed. It's not clear, according to detectives who testified, whether she is conscious or not. I saw somebody else already saying online that they've got these images of her unconscious on his couch. We don't know that, but it sounds like with the exposed breast, I mean, I guess, what is the significance of that? We know they've been on a date. We know they've been together, but we haven't seen anything so far that indicated they were romantic, that they were kissing or hugging, or that there was any sort of sexual activity. Now it seems like whatever's going on that couch inside his home takes this to another level. How significant is that?
It's very significant. So number one, it places her in his apartment, which I know has been a little bit of a known to a lot, but this confirms that she was in fact in the apartment on his couch at the time. I'd like to see these pictures myself, and I'm sure you would too. The way that they were presented in court does not appear to be a consensual type of situation with her face down on the couch, potentially unconscious. It certainly leads to a connotation that things were happening in that apartment that were not good for Miss Robinson. But again, I want to reserve my remarks on that until I actually see the pictures.
Well, and I almost missed this because I was busy doing, multitasking and doing other things as they're talking about the photographs. And your law partner, Julius Kim, reaches out to me and says, oh, boy, how about that screenshot of the what not to mix with bleach. And then I looked back and saw, sure enough, that was an exhibit that had been presented. That was one I wasn't expecting, didn't know was going to be there, because I think that's one of the things we've been looking for all along is, was there any evidence that he did anything to try and plan this out, or to plan to clean up the scene? How damning is that piece of evidence that there was this screenshot of what not to mix with bleach?
Brian, the phone is always damning to defendants. That search was incredibly bad for Mr. Anderson. One of the issues the state has had is, why isn't there forensic evidence located in the apartment? And a search about bleach certainly leads the state down the road to say that he was at least looking into how to potentially clean up a crime scene. And that type of search at the time when the search occurred certainly looks very bad for Mr. Anderson.
We know that when we come back after lunch that Anthony Cotton, the defense team, is going to cross-examine that digital forensic investigator. What do you think they're going to try to do with that? What can they, as you said, the cell phone says all. So what are they going to try to poke holes in here? If you were that defense attorney, what route would you be taking?
It's tough when you're dealing with cell phone data. The data does speak for itself, but I think they're going to try to point out that maybe these things didn't happen at the exact time the phone is saying, or some of these digital forensic items that are being suggested may have not been at the hands of Mr. Anderson, or may have happened at a different time. They're going to try to just poke holes into the timeline of all of this, but again, these pictures may very well speak for themselves, and these searches for bleach may speak for themselves. And I think they're going to do their best to just point out that there may be another explanation for this.
I know that throughout the week, Julius and I have been talking about the fact that we just still don't know where this crime occurred. And the state didn't seem, at least maybe until today, didn't seem to be really giving a theory of where it had occurred. Is there, and you start looking, where were the gaps in time? And if I look at the times that were presented today, the last interaction with that cell phone, the deleted images are at 12:08 a.m. They presumably leave at 12:45. The deletion of the searching for bleach, though, or the what not to mix with bleach, is at around, I think it was like 11:30. If they leave at 12:45, if the car leaves then, that's an hour and 15 minutes. Is that enough time to have Maybe by then he's already dismembered the body. Now he needs to clean it up because he's looking for the bleach question. But are they starting to raise a theory of, yes, even though there's no forensic evidence, that's where we think it happened? And do you think they have to do that? Do they have to give the jury a picture of a theory of where this occurred if they're going to complete a conviction here?
Yes, I believe the state and the defense will both give their own theories in their closing arguments. But this whole bleach thing certainly is going to lead the state down the road that he had sufficient time from the time he deleted the bleach search to 12:45 when they left to do the things that they're alleging and to clean up after the fact. So it's very possible the state is going to say that at least some of this behavior, potentially the murder and potentially the dismemberment, occurred at the apartment and he cleaned it up. They may also say that some of it occurred in the car. And I've mentioned many times that that car was torched and that car was burned. And they're going to argue that there was likely forensic evidence within that car that was intentionally destroyed through arson. So I think the state is going to probably say, we don't know for sure, but it does appear that there's a possibility that something occurred in the apartment and it was cleaned up. And certainly that car absolutely would have contained forensic evidence that was destroyed by the person who lit the car on fire.
So we know the state has one more witness after the cross-examination of the current witness, and then the defense gets the case. And we just heard from Stephanie Quirk that apparently the defense is planning to call maybe 5 or 6 witnesses. Throughout this case, this defense has really presented its case through cross-examination. So we've already heard a lot of what the defense is attacking here. But do you have any thoughts on what kind of witnesses we might see out of those 5 or 6? Are they going to be new individuals? Are they going to be recalls of people who've already been on the stand? What do you expect to see there?
So far, the defense's strategy has been to point out what the police may have missed, what the police should have done, didn't do, pointing out the problems with the investigation. But now the defense kind of goes on the offensive and starts presenting their own testimony. My belief is the defense is likely going to try to secure the theory that Ms. Robinson left Mr. Anderson's apartment at 12:45 on her own, that she was the person driving in the car with the fogged up windows, and that she left with her phone unharmed from Mr. Anderson's home, and that something happened to her after she left Mr. Anderson's home. So I'm anticipating the defense is going to call witnesses that would support that there's a potential other explanation for what happened to her that had nothing to do with Mr. Anderson. So they have a tough road ahead, but I'm assuming they're going to focus on the time that the state cannot prove, which is after 12:45 up until the point that the car is found burned on the north side.
And we know that that Maxwell Anderson's phone, we now know that it was off. It was not interacting in any way between, whatever it was, 12:09 a.m. and 9 something in the morning. I imagine the defense could point out that that would be consistent with having your phone turned off and you go to bed and you charge it back up in the morning or power it back up in the morning. The prosecution would probably say, well, he had turned it off intentionally and left it at home to sort of cover his tracks. Is that kind of what you would expect to hear from each of the sides to explain his phone being off for all those hours?
Yes, it's absolutely. The defense is going to say, look, he was at home. His phone was at home and he was sleeping. And the prosecution is going to say that he left his phone at home while he was driving around in Miss Robinson's car. I think the defense will also point out that if he was smart enough to leave his own phone at home, knowing that it could track him, why in the world would he have not noticed that Miss Robinson's phone was in the car and also tracking him? So I think there's some points the defense is going to bring up to try to prove that Mr. Anderson simply was at home and that Miss Robinson left his apartment unharmed with her phone, and she was the one that was driving that car.
It seems like they would have a tall order with that, though, because I imagine the state would point out that if he left his phone at home, or if his phone was there because he was sleeping, then what was he doing leaving the scene of the car fire at 7:30 in the morning and getting on a bus and riding it back home? They've certainly gone a long way to say that's definitely Maxwell Anderson who did that, and if the jury is convinced of that, then he was out there up on the north side for some unexplained reason right where her car is burning and on the bus back home while his phone was off at home. That seems like the state's got a pretty strong rebuttal to that idea that he was home sleeping.
That's exactly right. So if the defense theory is that something occurred to Miss Robinson after she left Anderson's home unharmed, why in the world is Mr. Anderson back in the fray the next morning at the burning car? So it doesn't make any logical sense that he would have been not related to the murder, but then show up at the burning car in the morning. Again, the state's theory has been you have to use your common sense. And that's the theme the state has tendered throughout this entire trial and through their opening. And that's what they're going to say at the end, is that it just doesn't make sense that Mr. Anderson would be at home sleeping when this all happened and then all of a sudden somehow get down to the burning car and then come back on a bus. So I think the state will easily be able to rebut the defense contention that something else potentially happened to her after she left the Anderson apartment.
In the end, the defense doesn't have to prove an alternative theory, but has to raise the question of reasonable doubt. And without the direct evidence, without a murder weapon, do they still stand a chance of being able to raise that doubt in at least one juror to say, they can't show you where it happened. They don't have the weapon. They don't have the DNA. Sure, it all looks bad, but that's just not enough. Do you think there's some possibility there still to convince at least one of the jurors that this just isn't enough?
I think anything's possible, and it's very hard to predict what a jury will ultimately decide. But I think it's going to be very tough for the jury to find reasonable doubt unless they truly believe that there was at least a potential for another explanation for this. I don't think they're going to acquit Mr. Anderson based solely on a couple of doubts about what the police could have done or should have done. I think the jury is going to have to talk about, is there a possibility of an alternative explanation for what happened to her that's unrelated to Mr. Anderson? So I think Mr. Cotton is going to have to develop at least an argument or a theory that he can present at his closing that shows that some other entity impacted Miss Robinson after she left Anderson's apartment.
So I suspect with one witness left from the state that the state will rest probably this afternoon unless that cross-examination of the digital forensic investigator goes on for a really, really long time. But the state could rest this afternoon. Defense with 5 or 6 witnesses may well get through them tomorrow. And then we go to jury instructions and ultimately to deliberation. Based on that, is it reasonable to say this is probably still going to extend into early next week? Or do you think there's any chance this could in fact get to the jury before the weekend?
As it happens in so many trials, these things sometimes end on Fridays. And courts don't like to do things piecemeal on Friday and then have people stay late into the hours on Friday. So with this complex of a case, I'm anticipating that the testimony and the evidence will probably conclude sometime tomorrow. And they may very well come back into next week for instructions and closing arguments. But again, it really depends, as you know, Brian, on how fast the defense case comes in and how many witnesses they actually call and how long those witnesses take. So I don't expect that the court's going to keep the jury there late into Friday night or over the weekend. I would expect that there's going to be a lot of discussion about jury instructions that's going to be outside of the presence of the jury. So I think this is going to go into next week.
Well, thank you for correcting me. I left out a big part there. After jury instructions, of course, closing arguments, which are huge, because that's where each side really tells the story that connects all the threads of evidence and the testimony that's been given so far. So that's going to be big. So with all of that, it sounds like we're going to be going probably at least into early next week. I don't know, with the number of cases that you have seen, I talked earlier, there were 62 law enforcement witnesses in this case and 12 civilians, a couple of other government people. 82 witnesses. I know it's not a record or anything like that, but that's an awful lot. Have you been involved in a case with this many witnesses from the state?
So I was involved in a full 2-week homicide trial a few years ago, and there was not as many witnesses as this. There was a lot more technical issues with DNA and some other issues. But in this case, there were so many law enforcement officers that were involved in small pieces of the case. So this was a pretty significant prosecution with a lot of evidence, a lot of witnesses, and was very impressive that it actually got done as efficiently as it did.
I just think about it's not often when your crime scene is not an isolated place, but actually a route and a path that goes all over the city. That seems to have really made this more difficult because they had to gather all of these individual cameras and pieces of evidence and all these other things. It seems like just unusual in the way there was such a large crime scene.
That's exactly right. And there were so many officers that had to track down all of these cameras and all of this data. So it was a very technical trial, and that's why it dragged on for a while. But today was very interesting because we kind of got back into the heart of the evidence. And I thought today was very, very compelling and was a lot more interesting than some of the more dry data evidence that we've been dealing with the last couple of days.
Well, Jonathan Lavoie of Kim and Lavoie, thank you for your time today. I know we've got a plan to have you in here again the same time tomorrow. We'll see where we are in the case at that time. But thanks a lot for your time here on the Wisconsin Live Desk.
Sounds good. See you then.
All right. Jonathan Lavoie of Kim and Lavoie. And we are going to take a quick break. When we come back, we will go into, again, some of what we have seen today. And I'm going to see if I can reach out and find out if we have some of those images. As always, I'll be here to sum up what we just heard and tell you what to expect. If you're just joining us now, we can tell you that there is one state witness left. We have heard from 82 state witnesses so far. That includes witnesses who've been recalled multiple times or who were continuations from a morning into an afternoon or from one day into the next. But nonetheless, 82 witnesses have been called to the stand, and 62 of them law enforcement witnesses. The one who is currently on the stand is a digital forensic investigator for the Division of Criminal Investigation. It's the Wisconsin Department of Justice. He worked on the cell phone extraction, the data from Maxwell Anderson's phone, the place along Lake Michigan, a beach, a secluded place that he called his, quote, secret beach, a place that he would take her to where they would take the dogs, they would maybe make a fire. But she said they'd gone there 5 or 10 times and it was secluded. They rarely saw anyone else around there, maybe someone walking their dog by very briefly. But she said it was a place he wanted to keep secret. He didn't want others to know it was their place, and he didn't even want her to take anyone else there if they ever broke up. Prosecutors asked her if she knew where that place was, and she said she didn't know the name of it. She only learned it was Warnemount Park after all the news came out about the leg being discovered there. But she was able to take prosecutors on a drive and use landmarks to find her way back to this place Anderson would take her to. And we have some of the images of that trip, of what she described. So when she gets to, this is the service road. I still keep looking for the photo that had the fence, and I don't know that we've got that one. I thought I saw it earlier. I don't see it in here anymore. In the ones that are accessible to me. Well, that's okay. Maybe this is it. Is this it? Yeah, there you go. That's the entry to the service road right off of Pulaski. And as you can see kind of in the middle, lower right middle portion of your screen, that's a security fence. that blocks that service road from traffic, from public traffic. It is the road down to the Cudahy Water Department's pump house. And she described going down that road with Maxwell Anderson, and once you get beyond the fence, that road descends down in toward the lake. So you see here it descends all the way down to the pump house. That's the pump house on the right. She described in detail how there was a rocky area that Maxwell Anderson would take the dogs and walk over. It was a direct access to the place he wanted to set up camp. She would take a trail off to the right that didn't have to go over the rocks because she would often be in sandals. And then she describes specific areas of the beach where they would go, including near a downed tree where there was some dead wood that they could use to make fires, and that's where they would set up. An investigator later who was on the stand, Detective John Galat, said that was in fact the location where Sade Robinson's leg was recovered. So right at this same sort of secluded, quote unquote, secret beach. It was John Galat who rode along with this ex-girlfriend to go find this spot. On cross-examination, the defense asked if he had ever, if their visits to this beach, if they had been, friendly and kind and whatever it was, or had he ever been violent with her? Had he ever engaged in any sort of violence against her? And she said no. The state used that and said that had opened the door to some other testimony. They were able to raise the point that Maxwell Anderson had in fact been violent before. In fact, he had gotten into a bar fight with this person's ex-boyfriend. So they had gotten into a fight at Trinity nightclub in Milwaukee. Don't know how significant that is, but it's certainly, the state wanted to refute any idea the jury might get that Maxwell Anderson was a peaceful guy who was never known to engage in any sort of violence. The rest of the day was really focused on that cell phone testimony, the cell phone extraction, and obviously the photographs. One more thing, though, that was really a key piece we hadn't been expecting, that we didn't know was going to be there, and that was among the images that were deleted from the phone, Detective Mason Colehap of the Milwaukee County Sheriff's Office, he said one of them was a screenshot. That screenshot of a website or something, it said something to the effect of what not to mix with bleach. And that was deleted at about 11:35 p.m. according to the testimony that was given by the forensic expert. So 11:35 p.m. he's deleting a screenshot that says what not to do with bleach. That's about an hour and 10 minutes before prosecutors say Sade Robinson's car leaves Maxwell Anderson's home and starts its ride all around the city, including going to Warnemont Park. So there's an hour and 10-minute gap between the deletion of the what not to do with bleach and leaving the home. Is that when prosecutors think he murdered and or dismembered Sade Robinson? Did he then clean up the scene using bleach and being careful not to mix it with something he shouldn't? Is that why the state was not able to recover DNA or blood evidence? Did he do a particularly good job with that cleanup? That certainly raises that question, and the state is going to probably make that case in their closing arguments. We'll have to see. What the defense will say about that also remains to be seen. What we know now is we have one witness to go for the state after the defense is done with Jason Ruff, the forensic investigator. And after the state's final witness, then the defense has about 5 or 6 we're hearing. I guess that's not official, but Stephanie said that's the talk around the gallery and around the room and the media, that there's maybe 5 or 6 defense witnesses that will be called. And then if that's the case, then we go to jury instructions and ultimately closing arguments. Best guess I can give you right now, the state is going to rest this afternoon. The defense really couldn't tell you. It's probably going to last through most of Friday, if not all of Friday, and then we'll be getting into some of the closing stuff, elements, next week. It's probably going to be sometime at least early next week, if not midweek before, but I would say probably early next week that the jury will get this case and begin deliberations. We are going to take a break and come back with more. It is 1:30. The court should be close to returning. This is the time the judge set for parties to return to the courtroom. We'll keep you posted and we'll get you back to the Milwaukee County Safety Building when we hear more about that, but we'll continue right here on the Wisconsin Live Desk right after this.
This is the Wisconsin Live Desk.
again until the following morning. Among those photos, and I'm going to show you the ones that we can again. Now, I want to be clear. These are not as they appeared in the courtroom. They have been edited and approved by our management team to be safe to show you. But what you're going to see here, there are a couple we can't show you at all because there was just no way to edit them in a way that was sensitive. But there are two in particular. These are such key pieces of evidence in the case. We wanted you to be able to see them for yourselves. And I'm going to start with this one right here, where you can see that circle that you see in the middle left portion of the screen was added by our editors. So that is not part of the original photo. Everything else in that photo is from the original picture that was shown to the jury. And that is purportedly, according to prosecutors, that is Sade Robinson face down on Maxwell Anderson's couch. Why do they think it's his couch? Well, we'll talk about that here in a moment. But in the very left middle portion of your screen, just outside the edge of that circle, you can see sort of a skin-colored looking, like an arm, shaft of an arm. That is apparently the wrist of what prosecutors say would be Maxwell Anderson's wrist, with a human hand that is behind that blurred circle, grasping or groping the breast of Sade Robinson. You see just below that circle, you see sort of that maybe rust or reddish color that's got some fading to it, and there's a seam in the whatever furniture that person is laying on. Well, take a look at this. That is Maxwell Anderson's couch. This is Exhibit 318. It's a photograph that was taken when the search warrant was executed on Maxwell Anderson's home early in April, after all of this had happened. And you can notice there on the couch that there's that blue, like light blue, kind of sky blue pillow. If we go back to the photo I was just showing you a moment ago, let me go back to that again, and you look just above the hair of Sade Robinson, you can see that light blue, or what appears to be that same light blue pillow. There is another image very similar to that one. This one also shows that sort of similar kind of light blue pillow. And of course, you notice in both of these photos, the sweater. Look at the cable knit pattern on the sleeve of that white sweater. Prosecutors say that is the same sweater Sade Robinson was wearing at Duke's on Water as she's sitting at the corner of the bar. This was on the evening between 6:30 and 9 o'clock on the evening of April 1st. The photograph you're seeing here with that same cable knit pattern of the sweater was taken after 9 p.m., after 9:20 p.m., which is after prosecutors said they arrived back at Maxwell Anderson's home on that same night. And then this particular photo was one of the batch of photos that they say was deleted from Maxwell Anderson's phone between 12:05 and 12:08 a.m., which would be about a half hour before prosecutors believe he left the house in Sade Robinson's car and started driving around the city. One other thing, there's another photo we cannot show you because there was just no way to edit it sensitively, and that is what we are told was Sade Robinson's pants and underwear being removed from her body on Maxwell Anderson's couch. And as it was seen in court and as it's been described by witnesses and by also our own Stephanie Quirk and others who were there, there was these light colored blue jeans that you see here. This is what was recovered from the burning car, Sade Robinson's burning car on the north side of Milwaukee on April 2nd at 7:30 in the morning. These were in the trunk. The trunk didn't burn. The inside of the car did. The trunk did not burn. These were recovered. You see the yellow bikini underwear that is right around kind of the knees, wrapped outside the legs. They say that is how, the prosecutors say that is how the clothing was found, and they say it's consistent with someone else removing those clothes. Now an image has been shown in court which shows these jeans and underwear that looks like that being removed from what appears to be Sade Robinson's body inside Maxwell Anderson's home. I just got word that Maxwell Anderson is back in the courtroom, and we're hearing, okay, I'm hearing some things in the courtroom. We're going to send you back to the safety building now.
Appearances.
Ian Vance Curzan and Megan Newport appear for the state, joined at council table by Detective Joanne Donner.
Good afternoon, Your Honor. Maxwell Anderson with Anthony Cotton and Jason Finlay.
Okay, good afternoon, everyone. This morning we received an email, well, Attorney Cotton received an email. It was also sent, I believe, to the prosecutor as well as to myself. However, my spam took it and I never was able to see it. Attorney Cotton showed it to the state as well as to me, and it reflected comments regarding comments posted to I believe, Law and Crimes website on YouTube, and a concern relative to that. The parties and I discussed it, and at the parties' stipulation, no further action was to be taken. Since this point in time, we've received further emails with the same information and attempts, I think, to contact my court as well as other courts. What we all know relative to the comments that are posted is some are accurate, some are inaccurate, some are made up, and Lord knows why people feel the need to post continuously. At this point in time, we've discussed it at length, and it's my understanding that the parties are stipulating to taking no further action. State, is that accurate, and is there any further record you wish to make?
That's accurate, and
So you telling me y'all stop in court because some people made some comments on the Law and Crime Network feed? Are you fucking kidding me? I'm telling you, the way they do shit in this city and state is unbelievable, folks.
no.
Defense.
That's accurate.
Okay, anything further to address on the record before we resume?
No.
Attorney Cotton, anything further you'd like to address on the record before we bring the jury in?
No.
Okay. And let's address that ringing.
Yeah.
We'll go from there. Special Agent Ruff, you can come back up if you'd like.
You just heard the judge instruct Special Agent Jason Ruff of the Division of Criminal Investigation, Digital Forensic Investigator. He will be on the stand undergoing cross-examination of his testimony about the cell phone extraction from Maxwell Anderson's phone.
Yes, please.
And also our private investigator, Jason Barber. Good afternoon.
Good afternoon. Good afternoon, everybody. Hope you had a lovely lunch. At this point in time, we are just about to begin cross-examination of Special Agent Ruff. We will re-swear him because we have a new court reporter.
Do you solemnly swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can please be seated, restate, and respell your name for the record, please.
My name is Jason Ruff. That is spelled J-A.
You know I comment every day, but surely outfits just be terrible. I know she trying to dress up for court, but she better off wearing what she wear every day. I guarantee you she wears stretchy pants, a little stretchy shirt, or a hoodie. Those outfits she got on are terrible. Sorry.
A-S-O-N, last name R-U-F-F.
Please proceed.
Thank you, Judge. Good afternoon.
Afternoon.
So you just recently testified that your job really was to analyze two different devices, right?
Correct.
Like a cell phone, then also a computer.
Correct.
But so you examine like the hard drive in the computer, right?
That is correct. Forensic image of the hard drive.
Okay, and so you said you're like a forensic expert on these types of analysis, right?
Yeah, forensic examiner.
And one of the goal, I mean, I guess one of the reasons you have the job is because you need to analyze people who are accused of crimes, their electronic devices, right?
Either people accused of crimes, victims, really anything related to a criminal investigation.
And it's because electronics are a pretty complicated, it's complicated evidence, I suppose, right?
Yeah.
And you have all these tools that you listed in your report that you use. You utilize these tools, and they can help decipher data from phones that you really wouldn't be able to get unless you had these tools, right?
Correct.
And so I'm going to start with the cell phone. And so these tools you use, you're able to determine, pull text messages, right?
Correct.
And even deleted texts, right?
Possibly, potentially.
And also you're able to look at someone's internet browsing, right?
Correct.
And that's something you did in this case, right?
Correct.
This is just me. But if I'm the defendant I would fire these lawyers. And two, my other point is, listen, man, they got the text messages of your guy texting this lady. He erased pictures of this lady that was clearly on his counts. Ain't much we have to ask him. We want to move on from him. We want to get him off the stand. We don't want the jury paying him no mind. We don't want the jury thinking about shit he said. There's nothing we can clear up. He erased pictures of the new girl that's dead. He erased pictures of the girl whose panties, who was found dead. What are you going to say? Oh, those pictures was, oh, damn. Just so luckily it happened that she had the same panties and outfit on when she was found dead, but he got old pictures. Doesn't make sense. So as lawyers, y'all suck.
And you're able to determine what website someone went to, right?
Correct.
Even if they use like the private browsing, is that right?
Yes, for the most part, yes.
And so in this case, you reviewed all of that, correct?
Correct.
And you didn't see any searches regarding how to, dismember a body, correct?
I did not.
Or you didn't see any searches about how to clean up blood, correct?
I did not.
Or how to dispose of a body, right?
Correct, I did not.
Nothing about how to remove DNA from a surface, right?
Correct.
There weren't any searches whatsoever about DNA, right?
Correct.
And that's on the phone.
Correct.
And then also you have access to the map application, right?
Correct.
I think of Google Maps, but I don't know, I'm not quite sure what's used on an Android, but there's some sort of map application,
Yes,
right?
yeah, yes.
And I think the jury all knows, when you type in, if you're trying to go to someone's house, you type in the address, and then that gets saved on your phone, correct?
Correct.
And Max's phone, this device that you looked through, there was no GPS coordinates to Warnemont Park, correct?
I would have to re-look, but I do not believe so.
Okay. And I think you would...
Why would he need to Google how to get to the park if his fucking ex-girlfriend testified that they used to go there, bro? You're dumb, bro.
Testified that the phone, shut down at some period of time, right?
That is correct.
I think 1:35 a.m., that sounds right, on April 2nd?
Correct.
But the phone wasn't turned off. It shut down, but it wasn't a intentional act of someone holding the power button and turning it off, correct?
That is correct.
It's shut off because it has 0% battery.
That's correct.
So perhaps, the user fell asleep or forgot to plug it in, right?
Anything's possible.
Are you serious, yo? Like I would fire you so fast. I would jump up in the middle of you questioning like, yo, Your Honor, I want to fire this motherfucker. I want to fire both of these motherfuckers, Your Honor. That's what I would say. Now it doesn't matter if the phone died or someone turned it off. This man testified to your client having pictures with his hand on her breast, taking off her panties. Bruh, what the fuck are you talking about?
And the data I guess you pulled, was there a certain time frame that you're looking at from this date to this date?
So the primary time that I was told was primarily the 12:45 a.m. to, I want to say 8. I would have to look specifically, but I believe it was like 8:50, 8:45 a.m. and just the time surrounding that.
Okay, so you're not looking at data like before April 1st, right? Oh, I guess you are, because I guess there's some text messages before that.
Correct. Yes.
Like there's not, you weren't looking at data from like early March or February, right?
Correct.
So if like the phone had the user had a repeated pattern of their phone dying, that's not something you would have seen.
Bruh, you fucking harping on the phone dying. That has nothing to do with this case, whether the phone died or not, bro. Yo, please, if you in Milwaukee, spread the word. Do not hire these two defense attorneys. They suck.
I did see that on the records that ERP is just a long list of all the power events.
And it died on April 4th as well, right?
Yeah, it died on April 4th.
Okay, so more than once this phone is dying, right?
Correct.
It's not just isolated incident to April 2nd, right?
Correct.
Yo, he wants to laugh. You can see it on his face. He want to laugh because he like, yo, bro, you talking about the phone dying, right? I testified to the conversation of your client with the girl. I testified to your client having pictures squeezing her titty. I testify to pictures that your client erased at 12:05 a.m. before he left his house in her car. Why are you asking me about the power shutting on?
And then let's move over to the computer. You had explained that, well, so the phone, you said user interaction stops around 12:07 a.m.
Correct.
On April 2nd, right?
Correct.
You said maybe to 12:08, but you're not sure. Pretty confident 12:07 phone activity, human activity stops, right?
Correct.
And then right around that same time, Netflix, so the computer, there's user activity on the computer, right?
That is correct.
So consistent with someone they cease interaction with the phone and start interacting with the computer, right?
Yeah.
And so 12:07, yes, according to, your analysis, activity stops with that electronic, but not all electronics in this residence, right?
Yeah.
And because a Netflix show is played at 12:07, right?
Correct.
And the show is played, and it sounds like these are probably pretty short episodes, right?
Yes, and from what I saw actually in some of the episodes for that Love, Death, and Robot show had been played the previous night as well.
Okay, but they're short episodes, like 10 minutes or less.
Yeah, like 5, 10, 15 minutes.
Okay, and in some of the photos, I think in your report, it looks like they're almost animated. It's like an animated show?
Yeah.
Okay. So it plays a few episodes back to back, right?
Correct.
And could you determine whether a user was actually clicking next episode, or was it just kind of timing out and playing repeatedly?
It was timing out and playing the next episode.
Okay, and then after those shows stop playing, the user, so this is a user, human being most likely interacting, playing a new show at 12:28 a.m., correct?
Correct.
And again, that action is physically done by a human, right?
Yes, they would have to physically transition over to that episode, or that show, I should say.
Okay, and I think a lot of members of the jury probably use, streaming services is when you can either search it, or sometimes I think you said you can get a suggested show and it pops up. It's like a show you might like, and you can just click watch and it plays, right?
Correct.
And these platforms like Netflix and Disney Plus, what have you, if you finish like a series, you don't even have to click watch a new series. Sometimes it'll just immediately queue it up and play it, right?
Depending on the browser you're watching it on, but yes.
Okay. And so 12:28 a.m., a new show is played, and that show is played in its entirety, correct?
Correct.
And you said that show's about an hour long, give or take?
Yeah.
And then after that episode ends, another episode is played, correct?
That's correct.
But that's actually auto-played.
Correct.
So it's not a user, because I think you can imagine it's the timer, that 10-second timer, 15-second timer.
Yes.
And it says you can either click play next episode, or you can just wait the 10 seconds, right?
Correct. I believe it's like 2 minutes or so on average.
Okay, so sometimes it's up to 2 minutes how long it waits. And so users don't actually need to click the button; they can just wait. Maybe if you don't want to pick up the remote, maybe you're lazy, you don't need to have to pick it up, right?
Correct.
I mean, I'm sorry, you don't have to pick up the remote to click the button, right?
Correct.
And so if someone fell asleep, for instance, the Netflix would continue to play, and the person doesn't actually have to interact with their TV, right?
That's correct.
And you say that according to the data you analyze, the show plays until at least, did you say 2:35 a.m.?
Yes, I believe that was the time.
And then does another show play after that, or were you not be able to tell because something with like the internet?
Yeah, so there was an interruption in the network when what I talked about, that IP lease, happened around the time when it would start playing another episode, which very briefly disconnected from the internet, like probably fractions of a second, but just long enough to interrupt that auto stream. So, yes.
Do you know if more episodes were played after 2:35 or not?
There were no episodes played.
Okay,
after 2:30.
so the episodes are done at 2:35 a.m., correct?
Correct.
But nothing about the data or anything that you analyze can tell you whether the user stopped watching the show, right?
You mean like to click off?
Well, like
the
data you reviewed can't tell you whether someone's actually watching the show or someone isn't watching the show.
Yeah, no, that's correct.
And then also, with your tools, you're able to look at internet searches, correct?
Correct.
On the computer, I mean.
Yes, that's correct.
It could be either Safari, Google Chrome, whatever internet browser people prefer, right?
That's correct.
And in a part of your job and in your experience, you've seen in criminal investigations where a user is, looking up things that, are consistent with them committing a crime, right?
Correct.
Or trying to conceal a crime, right?
Correct.
And that goes back to what I was talking about earlier about, how to dispose of a body, right?
Correct.
And were you aware of any facts regarding this case before you started your analysis, or you just going blank?
Very brief facts, pretty much. I mean, nothing, like no real in-depth facts.
But had you seen like news articles about it?
Yeah, pretty much just whatever everybody else was seeing was what I knew about the case.
Yeah, everybody else, because it was over social media, Facebook, Instagram, right?
Correct.
And sometimes, if you look on your Instagram feed, you'll see, a news story come up, right?
Correct.
And when you looked at, this Max's computer, you didn't see any information about how to remove DNA or how to clean up a crime scene, right?
I did not know.
And again, forensic investigators often rely heavily on history to evaluate intent, correct?
Correct.
And again, you found no search history on the computer consistent with planning or committing a crime, right?
I did not.
And just briefly here, you said that there were photos deleted. You could conclude that, right?
Yes.
And you included some photos that were deleted in your report of Sade, right?
Correct.
But there was other photos that were deleted as well.
Correct.
Did you say there was 32 in total deleted?
So there were 32 cache photos. I couldn't tell you the exact number of actual photos deleted. The 32 cache photos correspond to the time frame when the deletion was actually occurring. So not every photo gets a cache image. It depends on whether or not it's interacted with recently or really any number of things. So I wouldn't be able to say exactly how many photos were deleted.
And just to wrap up here, you also were able to pull the text communications between the two, right?
Correct.
And in those text communications, Sade Robinson's phone never sends Maxwell's phone her address, correct?
No.
Or the general area of the city where she lives, right?
Not that I saw.
I have nothing further.
State.
I have nothing else.
Thank you. State your next witness.
Dr. Karsten.
Do you solemnly swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated. State and spell your name for the record.
My name's Dr. Jordan Karsten. It's JordanKarsten.
How are you employed?
I'm a professor of anthropology at the University of Wisconsin-Oshkosh, and I'm also a professional consultant for the Wisconsin State Crime Lab through the Wisconsin Department of Justice.
What do you teach at UW-Oshkosh?
I'm a biological anthropologist, so primarily my work is focused on the human skeleton. So I teach classes in human skeletal anatomy, teach classes in forensic anthropology, biological anthropology, genetics, sometimes archaeology, depending on what's needed.
Could you just briefly summarize sort of your background in training and education?
Yeah, so in terms of education, I got 2 bachelor's degrees from Grand Valley State University in Michigan. One was a bachelor's of science in anthropology. The other was a bachelor's of science in health sciences. And then I got a master's from the State University of New York in Albany and a PhD my master's was in anthropology and my PhD is also in anthropology from the State University of New York in Albany.
How long have you been an anthropologist? I might have missed it.
How long? I graduated college in 2009 and I graduated my PhD in 2014. And I've been a professor at UW-Oshkosh since then in 2014, so I've been in the state for 11 years.
Were you contacted on or about April 3rd of 2024 by the Milwaukee County Medical Examiner's Office regarding a leg that had been recovered?
I was.
What was the nature of that contact? Why were they contacting you?
I was contacted by Charles Rohr, Dr. Charles Rohr, who is a forensic pathology fellow at the Milwaukee County Medical Examiner's Office. He told me that a human leg had washed up on the shore at Warnemont Park in Cudahy, and that he was interested in having me examine part of the skeletal remains to look at if the individual was dismembered, how that might have happened, and look to see if there were any tool marks present on the bone.
So what was requested of you was an examination originally just of the leg for a tool marks analysis?
Correct.
Okay. And as well as just a general examination of the trauma to the skeletal remains to see if you could figure out what happened?
Correct.
Did you in fact examine skeletal remains from that leg?
I did.
And over the course of the next weeks and months actually, did you also come to examine additional skeletal remains that were recovered related to this case?
Yes.
Did you subsequently prepare a report to document what you observed and what your findings were?
I did.
I'm going to show you what's been marked as Exhibit 409.
I don't object to this for the record.
Okay.
And it'll be received into evidence.
All right, 409 is received into evidence. That's your report, Dr. Karsten.
It is.
I'm going to pull it up on the screen next to you, and I would like to go through it with you in summation. And while I'm pulling this up, can you tell the jury overall what bones did you examine?
I examined a right femur, which is essentially complete, part of a left femur, left tibia, left fibula, right humerus, right radius, and a right ulna, as well as 2 cervical vertebrae and a patella, which is the kneecap.
And are you able to discuss an overall pattern of what you saw through your analysis of these skeletal remains?
Yeah, so overall pattern is the majority of the remains had some type of blunt force trauma, which had fractured the bones. And many of the bones had cut marks, and the cut marks themselves were superficial. They had what I call a V-shaped kerf. The kerf is the incision on bone, and so it was shallow, shaped as a V, and fairly regular walls. And those cut marks were found at locations across different bones, primarily in places where there are areas of muscle attachment and connective tissue attachment.
Okay, and did the fact that those were those cut marks to the bones were in those locations suggest anything to you?
It's consistent with the manipulation of soft tissue and dismemberment.
Were you able to examine or come to any kind of conclusions as to what kind of blades were used?
All I can say is that whatever caused the sharp force trauma, the blade itself had a V shape to it, and it was not serrated. So a serrated knife, like a steak knife, will produce a kerf, an incision in bone that's irregular. And this incision was not irregular. It was kind of uniform.
On any of them?
For all of them. There was no irregular aspect to the curves.
And based on the size of those cut marks and V-shaped markings, are you able to come to any conclusions about the size of the knife used?
I can't. When a knife comes into contact with bone, depending on the level of force, how much the knife actually contacts the bone, it can be very small kerf. You can push harder, make the kerf larger. So I can't say anything about the size of the blade.
Only thing you can say is whether the shape and then whether it was serrated or non-serrated.
In this case, yes.
And how is it that you're able to tell whether it's serrated or non-serrated?
Serrated blades will create, if you think of a serrated blade like a steak knife, essentially, they'll create a more irregular kerf or cut on the bone.
You may have mentioned this, but can you give some examples of some types of non-serrated blades?
Sure, like a paring knife would be a good example. You have plenty of blades in kitchens that are non-serrated. Simple blades. I mean, you could have like a fishing knife you'd use to fillet a fish would also typically be a non-serrated blade.
Were you able to identify blunt force trauma to any of the limbs?
Yes, on many of them.
Okay. I'm going to go through this, and let's start with, we're going to start with the right femur. If you want to flip to that page or follow along on the screen to your right. Let's talk about what you knew about the right femur, what you discovered.
Sure. So for the right femur itself, it has evidence of blunt force trauma. I don't know if we can go forward. Is that possible? So if you go to figure 1, you can see the complete right femur. The black arrow is showing an area that's approximately where there would have been force applied to the femur. If you go down to figure 2.
And just to be clear before I do that, this would have been the right leg, the leg
This is
that
the
was
right thigh.
from Warnemont
Right
Park.
thigh bone from Warnemont Park.
Okay.
So if you go down here, you can see a little bit closer on the right femur. The black arrow is the point where force would have been applied. And the way that we can reconstruct that is that bone is stronger in compression than tension. And so when blunt force trauma is applied to a limb, it causes a bone to bend. And in that process, the area that when it bends and goes into tension, that's where a fracture will start. And from the point in tension, the fracture shears over to the compression side. So can I point at this?
Yes, I think there's actually a microphone next to you if you can turn that on.
Okay. That work? Maybe not. Okay, that works. If you take a look here, you can see that if force was applied here, the bone would have bent, kind of bowed out like this, and then you would have had that area of tension right there where the fracture starts, and it shears over to the other sides. And then what happens is it removes this kind of rhomboidal shaped, or what often gets called lozenge of bone, and so that broke free. And so on the right femur, in this case, we actually have 3 different pieces of bone that result from this fracturing. One that's here that includes the femoral head, which goes into the hip socket of the pelvis, this lozenge shape of bone, and then the larger part, which includes the entire rest of the femur.
Would a person be able to apply the force necessary to cause this damage?
Yes, depending on the person and the circumstances, I believe, yeah.
You believe yes? Okay.
Correct.
Are you able to comment on the difficulty to cause this fracture?
It would be difficult, but it would be possible.
I'm going to move to strike that. In the last 2 answers and questions, he's not a use of force expert. I don't think he's been qualified in this topic that we're going into.
I can ask him some foundational questions.
Okay, lay the foundation.
Do you have any expert?
He's a fucking expert of cutting people up. I don't think he needs to be a fucking force expert. He knows what he examined.
Expertise in being able to determine what kind of force needs to be used to fracture bones in this fashion?
As part of my job with the Department of Justice for the Crime Lab, I will remove pieces of bone for subsequent chemical and genetic analysis. And so, yeah, I'm familiar with what is required to break bone.
So once again, I keep telling y'all, these defense lawyers, I think he was gonna go to jail. I don't give a fuck if he had the best defense lawyer in the world. He was gonna go to jail anyway. But to me, they not helping. They just be dumb.
I would ask then the objection be
Withdrawn.
okay.
And see, now he got to withdraw the rejection. So once again, the defense lawyer brought attention to shit that you just want them to say it and get the fuck off the stand. But you want to object to it, then now you want to withdraw your rejection because you don't know what the fuck you doing. I would fire y'all, but these are going to be great grounds for his ineffective counsel. They didn't know what the fuck they was doing.
All right, so let's pick up where I was left off here. On this part, on this femur bone, were there cut marks?
Yes.
Is this a good figure for that, or is there?
If you could move forward to figure 7. So on figure 7, you can see a close-up of the lozenge shape of bone. And then on the opposite side where the black arrows are, you can see a series of superficial cut marks. These are on an area that's called the linea aspera, and it is an area of muscle and connective tissue attachment.
And would that's the location of those cut marks suggests what soft tissue would have been being cut?
There are many muscles and aspects of connective tissue that connect there. You couldn't say exactly what.
What part of the body is this, I guess?
This is on the posterior side of your thigh.
So by your hip?
Below that.
Below your hip, okay.
Back of the leg, essentially, back of the upper leg.
Let's go to figure 11. How about this one?
Yep, figure 11 shows additional cut marks. So the black arrow shows like a roughly kind of horizontally oriented cut mark. In the red circle, there are additional cut marks, superficial cut marks, and then in the black circle, hard to see, but there are additional very faint cut marks.
Would the cut marks that you noticed when you examined the bones from the right leg from Warnemont Park, would that have been consistent to have been logically been in an effort to remove soft tissue?
Yes, it's in the area that's close to the hip.
Okay, the top of the leg.
Correct.
Are you able to tell whether the blunt force trauma to the bones, like we saw before, occurred before or after the sharp force trauma to the tissues?
For these, I cannot say.
You are able to conclude that it was the blunt force trauma that caused the fractures?
Yes.
All right. Anything else about the right femur?
Figure 12 shows an additional couple of cut marks.
Okay.
This is on the front side, anterior side of the femur, in an area that's known as the intertrochanteric line, which is another area of ligamentous and muscle attachment. If you go to figure 13, you'll see even more cut marks. This is on the lateral side of the proximal femur, so the part that's closest to your hip. The black, red, and blue arrows all point to individual cut marks on that figure. And then on figure 14, up on an area that's known as the greater trochanter of the femur, which is another muscle attachment and area of connective tissue attachment, you can see more cut marks, superficial ones with the red arrows, and then with the blue arrow, you can actually see one where the cut mark has kind of peeled back the bone. And so that cut mark must have been delivered in a kind of up, kind of above body to below, so what we call superior to inferior direction.
Would it be fair to say that the cut marks you observed were generally concentrated, towards the transection end of the leg?
Not just in the, I wouldn't say like in the hip.
Okay.
It's from kind of the upper third of the leg is where we are finding the cut marks.
All right, let's move on to the left tibia. What did you observe about the left tibia?
The left tibia has one aspect of blunt force trauma. So if you look at figure 16, you can see the tibia is separated and the tibia is the shin bone. Figure 16, that's the upper part of the tibia. So that kind of plateau area is what makes up your knee. And then if you go down to figures 18, you can see on the left, that's the upper part of the tibia. In the middle and removed, that's this lozenge shape of kind of rhomboidal shaped bone that gets removed during bending fractures caused by blunt force trauma. And then on the right is a shaft of the tibia. And then if you go to figure 19, you can see without that lozenge shape how it goes back together. And if you go to figure 20, you can see that lozenge shape is replaceable into the break. And so in this case, if you could go back to figure 19 quickly, where that black arrow is, that's where the force would have been applied. So this is on the medial side, so the inner side of the leg, with the force moving from the inner side of the leg to the outer, what we'd say is medial lateral force. And so it broke on the far side away from the arrow.
You use the term butterfly fracture here in the description. What is that?
Butterfly fracture is a term we just use for these fractures where bending of the bone has that lozenge-shaped breakaway. And so it tends to break away this rhomboidal piece of bone that kind of looks like one wing of a butterfly.
Okay.
Sorry.
I was just going to ask you whether there were cut marks to the bone that would have separated the bottom from the ankle.
Yeah, if you go to figure 22, this is the bottom part of a fibula. So this is where your shin bone comes into contact with your ankle. And you can see with the black arrow, one of these superficial cut marks across that part of the bone. If you go to figure 23, you can see additional, this is twisting the bone around a little bit. You can see additional cut marks highlighted with the arrows, and an area of bone that was damaged in the black circle. And if you go to figure 24, this is twisting the bone around to what's known as the medial malleolus. So this is like the big bump on the inner part of your ankle. You can see another couple of superficial cut marks there as well. So cut marks around the distal part of the femur, lower shin bone.
All of these cut marks, these superficial cut marks, all the ones we're talking about, these are all from some kind of a non-serrated V-shaped blade?
Yep, they're what we call V-shaped kerf. So they're superficial, they don't go deep into the bone, and they don't show any hallmarks of being serrated because the kerf is not irregular.
Intentional cut marks?
There's only one way to cut into bone, and that's by purposely putting a knife there.
Only way to one way to cut into tissue as well.
Correct.
Let's move on to the left fibula. What did you notice?
Left fibula has two instances of blunt force trauma. If you look at figure 25, you can see with the black arrows the area where the force would have been applied, and it's just like the pictures we've seen so far. It's these butterfly fractures, bending fractures. In this case, the force would have been applied anterior to posterior. So the fibula is a bone that is in your lower leg. It sits next to your shin bone on the outside of your shin bone. And so those two areas of force didn't actually have enough force to cause the bone to completely break. And so you can't remove those lozenge-shaped pieces of bone. That bone still is a single element that's not separatable.
And regarding cut marks on the left fibula?
There's a single cut mark on figure 28. So this is an area that's just above what's known as the lateral malleolus. And so that is the bump on the outer side of your ankle. And just above it, where the black arrow is, you can see another one of these kind of horizontally oriented superficial cut marks of the V-shaped curve.
Anything else about the left fibula?
No.
All right. The right humerus, what's the humerus?
Humerus is the bone of the upper arm.
Let's talk about the right humerus.
In this case, in figure 30, you can see the head of the right humerus. This is what makes up your shoulder joint from your upper arm. Only that is present here, and there is a fracture to the bone that's removed it from the rest of the humerus.
Is the removal of the humeral head evident of evidence of blunt force
This
injury?
likely is, yes.
Okay. Let's go to the left femur. This was the, well, let's talk about the left femur. Go ahead.
Okay, if you go to figure 34.
Sure.
The proximal left femur, so the part that's closest to the hip, the head of the femur, what goes into the hip socket, is preserved, as well as part of the neck of that. But then there is what we call a comminuted fracture. And so you've got a blunt force impact that has taken the bone there and broken it up into many small pieces. And so that has destroyed, all those fragments are still adherent, the lateral side of this femur. And so force was probably applied in a superior, so upper lateral down to inferior medial, so kind of direction.
Okay. Any cut marks?
On this part, the superior part of the left femur, no. If you go to figure 36, you can see additional aspects of blunt force trauma. So the black arrow shows blunt force trauma that removed a lozenge shape of bone, but that was never recovered. And then the red arrow shows another one of those fractures, just like we've seen in the other pictures of this kind of butterfly fracture that was also applied to the femur. And then at the very far right side of the picture is another one of these bending butterfly fractures caused by blunt force trauma. And so in this femur, we've got at least 4 instances of blunt force trauma to the left femur.
And how many of those instances were consistent with the right femur?
They're in very different places than the right femur.
Okay. Any evidence of cut marks?
Yes, if you go to figure 42. So every black arrow is a superficial cut mark on the anterior femur. There's at least 11 superficial cut marks there. In this picture, there are 7 that are highlighted. If you go to figure 43, you can see one of these a little bit more close up. In this case, that cut mark exhibits what we call kerf flare. And so that is where you can see the cut marks are almost superimposed one on the other. And this is something that you see when a non-serrated blade is used in a sawing motion.
All right, so this was evidence that there was a sawing motion to cut the tissue around the femur.
Correct.
Okay. All right. In June, much later, you had received bones from the right arm that had washed up in Waukegan, Illinois, correct?
Correct.
All right. Let's talk about that right arm. What did you notice?
If you go to figure 46, in the area with the black circle, you can see cut marks that are on the side of the humerus, the proximal humerus is up towards the shoulder. On the medial side, so the side that's like kind of towards your armpit, there were no cut marks. If you go to figure 48, you can see that on the kind of lateral posterior side, there are additional cut marks highlighted in the black circle. These are kind of difficult to see, so if you go to figure 50, I'll go up actually.
Sorry.
Yep, there's a close-up picture here of the cut marks on the humerus. And so you can see here several of these V-shaped curved superficial cut marks on the proximal humerus. So this area is known as, this includes the greater and lesser tubercle of the humerus, and these are areas of muscle attachment for the shoulder.
Was there similar indication on these of a sawing motion being used?
Yeah, some of these curves are kind of superimposed one onto the next, and so likely reflects sawing motion.
And that would have been an intentional act?
Yes.
All right. How about the radius?
If we go to the radius, if you could look at figure 57.
57, okay.
So the radius is a bone, the forearm. And on figure 57, you can see the black arrows highlighting a single superficial cut mark on the distal part of the radius. This is the part that's towards your wrist. If you then go to figure 61, you can see a close-up of that. Could you go up just a little bit, I guess?
Sorry.
Yeah, you can see a little bit better that superficial cut mark. If you go down to figure 62, you can actually see a good example of kerf flaring. And so that's where you've got this cut mark, but on the end, the kerf, there's actually a couple of different.
It's crazy to me that if he did this, he's just sitting there watching it, admiring his work. They showing, you know, how he cut the body up and how he did this. And he's just sitting there like, it's nothing. The way people's minds work is amazing to me.
Different tracks to that knife, and that again is something that's consistent with using a non-serrated knife in a sawing motion. And then in figure 63, that close-up gives a good example of what I mean by a V-shaped curve. That's incision in the bone, takes on a V shape, but it has a very regular floor to the kerf, which is something that you see in a non-serrated blade.
So the person who caused these marks that I'm looking at here in 62 was intentionally sawing at the bone with a non-serrated blade?
They were sawing at the bone with a non-serrated blade.
Any cut marks near the elbow?
No.
And you had looked at the, anything else on this?
For the ulna?
The right arm?
Yep, so the ulna is another bone of the forearm, makes it kind of the inner part of the forearm. And if you go up actually just a little bit, at 67? Okay, 67 shows the location of two of these superficial cut marks on the ulna. This is the distal part, so the part like towards where it's at is towards the wrist. The part on the left side of the screen is towards the elbow. And if you go to figure 68, you can see them a little bit close up there, the superficial cut marks on the distal ulna.
Anything else on this one?
No fractures to the ulna or the radius.
You examined some of the cervical vertebrae?
Yes.
Next? Okay.
Was given two cervical vertebrae to examine.
And where were those from on the body, if you could just help us
Cervical
out?
vertebrae is the vertebrae that make up your neck.
And what did you notice when you looked at the cervical vertebrae?
No evidence of cut marks. The only trauma was on the most superior of the two cervical vertebrae. And if you look at figure 69, you can see that on the right side of the cervical vertebra, on a feature that we call the transverse process, there is damage to the top of it, highlighted with the black and red arrows, and that's likely caused by blunt force trauma.
Blunt force trauma?
Likely, yes.
And lastly, the patella. What is the patella?
Patella is the kneecap.
What'd you notice?
No evidence of trauma or cut marks.
That was from the left leg?
Let me double check. Yes, left patella.
Are you aware, or can you speak on the time frame it would take a person to cause the damage that you analyzed in these figures?
I don't think I could give an estimate of that.
I have nothing else.
Cross.
What you can give an estimate on is just how difficult it is to remove bones from a human body without the right tools, right? You can take that down, Ian. Okay.
I have never, I've removed bones from each other with tools. Yes.
Right. What types of tools?
If I was going to separate two bones from each other for the purpose of an examination, I would use a scalpel. To get through soft tissue.
Right, to get through soft tissue.
Correct.
So I thought before you had said you have experience removing bones from a human body, no?
I've experienced removing bone from bone, like breaking off a piece of bone for sampling, and separating bones from each other for the purposes of an.
Right, he was asked earlier if he can testify on force, and he said he had broken bones, so he knew the force. But good try, trying to confuse the jury. I'm telling you, these lawyers suck.
Analysis.
Okay, so you've taken two bones apart on occasion for your work.
Correct.
But you've never done an autopsy.
Correct, I'm not a pathologist.
Okay, and are you able to speak to how much force is required to remove bones from a human body?
Yes, I mean, for me, when I do it, I typically use something like a small Dremel tool, and we can use that to remove pieces of bone from the human body, so a small motorized saw.
Okay, a small motorized saw.
Correct.
What do you
remove small pieces?
Okay, and what do you wear when you do that?
Protective glasses, protective mouth and nose coverings.
Why?
I would rather not breathe in bone dust.
Okay, bone dust would get on you.
If I was using a saw, correct.
And if you're removing a bone, if you're cutting through flesh, you could get bodily fluids on you.
Correct.
Blood,
Yes, correct.
other such fluids that would just be within the body, right?
Correct.
It would be a very messy process to dismember a body. You would agree with that?
Depending on the condition of the body, yes.
Right. If a body was newly deceased in particular, it would be particularly messy.
I don't have experience with that.
You have no experience with dismembering, taking body parts off of a newly deceased body.
No, anthropologists tend to get involved when there's considerable decomposition or complete skeletonization.
And obviously things become weaker with age, right? Things degrade.
Depends on the context of deposition.
Well, but you would agree with that proposition, wouldn't you? That bones don't get stronger as they over time.
I actually disagree with that. So if
As a lawyer, you don't ask questions you don't know the fucking answers to. So now you try to make it sound like, oh, bones get weak as they get older. She disagrees with you. You shouldn't ask that fucking question if you didn't know the fucking answer. I'm telling y'all, these lawyers that he got didn't help him. He was better off representing himself.
you have a bone that's deposited in like say a soil matrix that has large mineral content. I have excavated personally bones that are 6,000 years old that are heavier, beefier, and stronger than fresh bone.
Got it. Here we're talking about new bones that are not 6,000 years old, sir.
Correct.
Okay. So these.
So, yes, you're not talking about bones that are 6,000 years old, but your question was that do they get weaker over time? The answer is no, not always. You are a dumb lawyer. Move on from your point. Your point ain't gonna work. As a lawyer, you should know that. Move on.
Bones, as you understand it, were the bones from somebody who was recently deceased. You understand that, right?
Yes, definitely.
And that the bones were located out in nature, right?
Yes, correct.
Not in a special soil matrix.
Correct.
And they were found in various parts of nature, water, the woods, things like that.
That's my understanding, yes.
And all I'm asking you is, would you agree with me that as time goes by in those conditions, things will tend to degrade?
Yes.
Okay. Now, the size of the knife, or if it was a knife, you have no idea if it even was a knife, do you?
It's a sharp blade.
Or it could be an axe.
It would be very unlikely to be an axe.
It could be an axe.
To make those kind of cut marks would be very, very unlikely.
So he answered your question. It would be very unlikely. You're trying to force him to say, yeah, it could be an axe. It could be an axe. Bruh, move on from these questions. You look stupid. Please.
Well, that's for the cut marks. But for other parts of what you looked at, it could be an axe for other things.
For the blunt
right?
force trauma, that would definitely be a possibility.
Right, where we're seeing the bone itself literally fractured, right?
Correct.
Because when you're telling the jury about blunt force trauma, you're talking about the one of the exhibits we saw was literally part of the proximal right femur broken off, right?
Correct.
So you wouldn't rule out an axe on that?
No, not at all. Axes can impart blunt force trauma because of their wedge-shaped action. And so if an axe is used and is applied with force to human bone, it doesn't necessarily make a cut. It can result in strictly blunt force trauma.
Were you given pictures of items that were recovered from? You understand Mr. Anderson's accused of this crime, right? Do you
Yes.
understand that? Were you given pictures of items that were recovered from Mr. Anderson's home and asked to offer an opinion? Let me finish. About whether these items were used in this dismemberment?
Not that I have any recollection of.
So no.
Correct.
No axe given to you to say, was this used?
No, never.
Or pocket knife or anything else?
No.
And we'd have to ask you said a forensic pathologist could speak more intelligently about the level of force you required to fracture bones, right?
Yes, I would think so.
For example, when you talked about the the proximal right femur, you know that it's a lot of force needed to break a femur bone, right?
Correct.
How many hundreds of pounds of force, or you can't speak to?
I couldn't say in that bone, and its mechanical properties varies person to person.
Some bones are stronger than others, just
Also
because
true.
of their calcium concentration, right?
Sure. Yes, correct.
And what you do know, or what you've been able to identify in your report, is basically, let's just go to the bottom line conclusion. Bottom line conclusion is that some sort of sharp instrument was used to remove bones from a body.
Yes.
Okay, you can't say that Mr. Anderson did that.
No.
You can't say who did it,
Correct.
or where it happened,
Also correct.
or even the item that was used for it.
Also correct.
Okay, that's all.
What did he prove? Nothing. You could have just not questioned him. Oh, you can't prove. It's not his job to prove who did it. That's not what he is. Like, these lawyers suck. Please, if anybody ever watched this video 5 years, 10 years from now, and they see these two lawyers, please tell everybody in Milwaukee never to hire these two lawyers. They suck.
State.
I have nothing else.
Thank you, Dr. State.
The state has no more witnesses. The state rests.
Uh-oh.
At this point, I need you to put your notebooks on your chairs, and you need to give me a couple minutes to address some matters, then we'll be back with you. Okay? Thank you, everybody.
We about to get a verdict soon. First covering of the court trial, we gonna get a verdict. I'm deeply invested.
Raising a multiplicity challenge, I think that these are, I want to raise a move to dismiss at the completion of the state's case, Your Honor, on all charges, but specifically I want to raise a multiplicity challenge to the newly added charge of hiding a corpse. We started with the mutilation of a corpse charge. The state amended the information, of course, before we began. Raising a multiplicity challenge, I think that these are essentially in this context with the same victim, the same body, essentially the same crime or the same elements, if you will, and I think one should be struck.
The hiding and the mutilating are two different acts, and so there's not they don't have the same elements. They're two different crimes and require two different criminal acts. Certainly they can overlap, as I think the evidence showed they did here, but those are two different crimes. So that would be my response to that.
Just a moment.
What, is there a judge in the back and you gotta go ask him for the goddamn answer? You just was in the middle of a fucking, and you just gets up and go? That's crazy. Like, she had to get up and go get some answers from somewhere else. That shit don't even make no sense. That she just got up in the middle and left.
Sure. First. Okay, so relative to multiplicity. Multiplicity exists when a defendant is charged in more than one count for a single offense. And the double jeopardy provisions of the state and federal constitutions protect a defendant from being punished twice for the same offense. Under Wisconsin law, we employ a two-pronged test to determine whether charges against a defendant are multiplicitous in nature. First, whether the charged offenses are identical in law and fact. And second, if the offenses are not identical in law and fact, whether the legislature intended the multiple offenses to be brought as a single count. In this particular case, the defense is arguing that the two counts relative to hiding or burying a corpse is charged in count 4, and count 2, mutilation of a corpse, are multiplicitous. So looking at the elements, which is one of the standards that has to be reviewed, I need to look at whether or not the offenses are identical in law and fact. As to the mutilating a corpse, there are two elements. It's first that the defendant dismembered a corpse, and second that the defendant dismembered the corpse with the intent to conceal a crime. Looking at count 4, the two elements of hiding or burying a corpse are one, that the defendant hid a corpse. Second, that the defendant hid a corpse with the intent to conceal the crime. There clearly are different elements in law relative to the two offenses. As to the difference in fact, there are different acts that would be different actions that would be involved in dismembering a corpse versus hiding a corpse. So I think in this particular matter, the two offenses are not identical in law or fact. I next need to look at whether the legislature intended that multiple offenses be brought as a single count. And in so doing, you look at whether or not the legislature, in the drafting and creation of the statutes, set out different elements under Blockberger that amounts to the fact that their intent was to allow for different crimes to be prosecuted under the same subsection. At this point in time, looking at the facts and looking at the law and doing an elements only test, I am going to find that the two offenses moving forward are not multiplicitous and that they are allowable. So I'm denying the defense motion relative to multiplicity.
Of course you gonna deny their motion, because they stupid. It was a dumb act. Like, they don't know what they doing, so thank you, Judge, for letting them know they don't know what the fuck they doing, and they some dumbass attorneys.
Defense.
Yes, I made a motion for directed verdict on all counts, Your Honor.
Do you wish to make any further argument?
No.
State.
Not unless you would like an argument.
No. So what I can tell you, Mr. Anderson, is at the close of the state's case in chief, what the court has to do is has to look at the evidence in the light most favorable to the state. So looking at the evidence in the light most favorable to the state, was the evidence adduced, believed, and rationally considered sufficient to prove guilt beyond a reasonable doubt? Or in other words, has the evidence that's been presented during the course of this trial in the light most favorable to the state of Wisconsin, could a reasonable jury find you guilty? Looking at the facts underlying this matter, the evidence that's been presented during the course of this trial, to some extent, would be that on April 1st, you were at the Twisted Fisherman with Sade Robinson, that you arrived at 5:09, that she arrived at 5:20, that you both left the premises at a 6:24, that you then proceeded to Duke's on Water, arriving at 6:35, leaving the establishment at 9:04 p.m., that you proceeded to Anderson's home, 3161 South 39th Street, and arrived approximately 9:20 p.m. What we know is that on April 2nd of 2024, at Warnemont Park, at 2:53 a.m., the Civic arrived. At 4:32, the Civic departed. We know that on that same day, the leg of the victim was found. What we also know is that we watched a number of videos that tracked the progress of the vehicle, the Civic, around different aspects of Milwaukee. The videos at no point showed the driver or whether the driver was the sole occupant in the vehicle. at least not clearly. At 4:44 a.m., there was a white spot at a window and a lighter flashing or a lighter appearance in the driver's seat. Whether the white spot was a white hand or the white shadowing was a white person in the driver's seat, or whether that was a glove, that's going to be left to the weigher of credibility. At 7:30 a.m., we know that the Civic was set on fire behind the abandoned building. We know that the seat was in a position that fit a person who's 6'1". We know that your measurements are that on the time this happened, you were 6'1" and a weight was approximately 180 pounds. We heard the testimony that the value of the Civic was approximately $20,000. And based on the videos that were presented, a reasonable jury could conclude that that was you, that was in an approximate distance from the burning vehicle, that you left the area of the burning vehicle shortly after it appears it was set on fire, that you traversed and entered a bus at 8:07 a.m., that you exited the bus at 8:34 a.m., that you were arrested on April 4th, and during the course of the arrest, you were visibly shaking. On April 4th, 5th, and 16th, search warrants were executed at your home. At Galena Park on April 5th, there were parts of the victim that were recovered in the form of different pieces of flesh as well as a left foot. There was blanket found, small flesh, bone, and large piece of human leg on the 6th, and there were ball joints with ligaments recovered on the 7th. From the testimony that was adduced during the course of this hearing, I don't think those bloody gloves that were found on April 9th had anything to do with anything. And we know that the torso with the arm were recovered on Marina Road on the 18th. We heard the testimony from the medical examiner that the death was homicide by unspecified means. And we heard the Life 360 and phone information and tracking information, which reflect that the phone of Sade remained at your house until 9:24 p.m., that the phone ultimately thereafter was not stationary, that it went down Capitol to the Mitchell Parkway to Warnemont Park, remained static at Warnemont from 2:40 to 4:33. It was in Warnemont Park, I believe, from 3 to 4:30 a.m. The last communication with the phone was on East Howard when the battery died. We know that Sade was reported missing on April 2nd, that you were the last person in communication or in presence publicly with her, that the videos of your home were poor quality. The testimony by Detective Rachel Smith was noteworthy. She indicated that she spent hundreds of hours viewing this video of your house and watching those hundreds of videos. And she basically saw the arrival at 9:20 p.m. and that the Civic departed on April 2nd at 12:47 a.m. She went through all of the testimony relative to the timing about the gate opening, the outdoor movement and gate not opening, the silhouette exiting the gate the same size as the fence at 11:25, the light going out at 11:27, 11:42 a person goes into the premises, the motion light goes on for human movement with a person the size of the fence at 11:56. At 11:58 we have human movement at the back gate area. At 12:12, we have the gate closing again. 12:42, we have human movement inside the premises. And ultimately at 12:47 and 20 seconds, we have the Civic leaving the house. We also have the fact that on the bus video, you return to your residence at 8:42 a.m. wearing the green hooded sweatshirt and dressed differently. We have the fact that you went to the dugout on the following day for work. Noteworthy, we have the photos that were recovered from your home. It's noteworthy that the photos of Sade reflected her buttocks and her underwear pulled down as if the underwear were pulled down with the pants and that it rolled over the pants, which is pretty much just how they were found in the trunk of the vehicle that was set on fire, that you were found walking away from. We also have the fact that there's a photo of a white hand grabbing her right breast and the right breast is the breast that was dismembered from her body on the torso that was recovered. We also have the fact that there was the photo of bleach and what not to combine with bleach, which I think a reasonable inference could be that someone on your phone was looking for information relative to how to clean up something or a crime scene. So looking at all of these factors together, it's a circumstantial case, but as we know, according to our jury instructions, circumstantial evidence may be found to be stronger than direct evidence. And at this point in time, I am going to find that a jury acting reasonably could convict you on all charges as posed. So I'm going to deny the defense motion, and what that means is I'm going to allow this matter to proceed to the jury. They have a different balancing than I have. So at this point, my view is, in the light most favorable to the state, do they have the means to convict? A jury at the conclusion of the case, their job is to determine whether or not the state has proven each and every element beyond a reasonable doubt. So I deny the defense motion. Have you spoken to your client, or do you need...
That was dumb. You really, like, I know lawyers gotta do their job and all that, but did y'all really think she was gonna dismiss the fucking case with all that fucking evidence against him, and y'all, his defense lawyers, help with the evidence against him by asking dumb questions of people you should have just let get the fuck off the stand so we can forget what they said? Dumbasses. Please, Milwaukee, put the word out. These two lawyers suck. No one should hire these lawyers. Every time y'all see these two lawyers, y'all should tell them they suck. And no, I'm not rooting for him to beat the case. If he did it, I want him to go to jail. But I just don't think those lawyers did their best work. I don't think those lawyers did him any good. I think he could have got the same results that he got right now representing himself.
Need a moment to speak to him.
No, 1 minute, please.
No, Your Honor. I don't need to speak to 1 minute, please.
Okay. Have you spoken with your client relative... Well, let me ask you this. Do you intend to present any witnesses other than the defendant?
Defense rests.
Okay. So, Mr. Anderson, have you just...
The defense rests? He going to jail. He's going to jail. Y'all don't have no witnesses, no nothing. Nobody's going to come in. His mama, daddy say, oh, no, he's a good guy. He would never do nothing like that. Nothing? The defense rests? Wow.
discussed with your attorney your constitutional right to testify as well as your constitutional right not to testify?
Yes, Your Honor.
And has your attorney answered all your questions?
He has, Your Honor.
And you understand that in a criminal case, you do not need to prove your innocence, but the state must prove your guilt beyond a reasonable doubt. Understood?
Yes.
And you understand that if
these lawyers gotta be like looking for their next case, they gotta understand they lost. They don't have no witnesses, no nothing. They didn't do good on cross-examination. We know he's finna get 100 years. But then again, like the judge says, the juries may think different, but basically she said you guilty as hell, my nigga.
if you choose to testify, you would be subject to cross-examination by these prosecutors.
I understand.
And you understand if you choose not to testify, that cannot be commented on by anyone. That cannot be used against you. Understood?
Yes.
And have you had enough time to discuss this decision to testify or not to testify with your lawyer?
Yes, Your Honor, I have.
Have your attorneys provided you with their professional opinion?
They have.
Has anyone, including your lawyer...
Sorry to tell you, bro, they professional opinions suck like a motherfucker. Don't rely on them.
Lawyers made any promises to you or offered you anything to arrive at this decision?
No, Your Honor.
Has anyone, including your lawyers, threatened you or coerced you in any way to arrive at this decision?
No.
Do you believe you're making this decision freely and voluntarily?
Yes.
Do you have any questions for me about this decision?
No.
Do you believe you're doing this with full understanding?
Yes.
Have you used any drugs or alcohol in the past 24 hours?
No.
Are you taking any medication that would affect your understanding of these proceedings today?
No.
After thinking through everything we just talked about just now, is it still your decision not to testify?
That is my decision.
Attorney Cotton, have you discussed with your client his constitutional right as well as his right to testify as well as his constitutional right not to testify?
Yes, just to be clear, it's been a subject of course discussion throughout this case, including the last 2 nights after trial. We've had jail visits to discuss that. Mr. Findling and I have both discussed it with him.
And are you satisfied he understands what his rights entail?
He does.
And have you advised him of your professional opinion?
Yes.
And are you aware of anyone making any threats or promises, using any force or coercion towards him in respect to this decision?
No, I'm not aware of any such threats.
Are you so satisfied that he's making his decision freely, voluntarily, knowingly, and with full understanding?
Yes.
I am as well. I in fact find that the defendant is waiving his right to testify, and he's doing so freely, voluntarily, knowingly, and with full understanding. Let's proceed at this point in time to do a conference relative to jury instructions and verdicts. I've printed off new verdicts for you. Prior to the matter being called, the state indicated they were seeking a lesser included on count 1. I did add in 1018. Is that still the state's position?
It is.
Defense, did you wish to be heard on that?
Yes. Give me 1 minute, please.
Okay.
It's a new development. Okay, no, I don't need to be heard on that, Judge. I don't have any, I've discussed it with Mr. Anderson, and I don't have an objection to that.
It's basically what I need to look at is whether or not a jury acting reasonably based on the evidence presented during the course of the trial could come to a reasonable decision on a lesser included. And that's the analysis the court has to make when a party requests a lesser included. In this case, I find it's appropriate, and I will add in the lesser included, so we will use 1018. So my intention relative to the instructions would be 100 opening instruction, 115, 1 defendant, 4 counts. Count 1, 1018, first degree intentional, followed by first degree reckless. Then moving on to 1193, mutilating a corpse. 1408, arson of property other than a building. 1194, hiding or burying a corpse. Then proceeding on to evidence defined, 103. Then 147, improper questions. 148, objections of counsel, evidence received over objection. I don't think I ever struck any testimony. Did I?
I think
It was asked, but then I think you withdrew.
Yeah, I don't recall any testimony being stricken.
Attorney Cotton?
Yeah, there was one comment where a witness had said they instead of the civic. That was struck, but
I'll leave it in. It's it's 2 sentences.
Yeah.
157, remarks of counsel. State, I'm sure you want 170, circumstantial evidence, and 172, circumstantial evidence, flight, escape, concealment.
Yes.
Then 190, weight of evidence. 195, juror's knowledge. I put in 200, opinion testimony. I took out the word expert because I think that's inappropriate to have in the title. 141, I assume the defense is requesting.
yes.
201, opinion of a witness. I put that in relative to Detective Donahue's testimony when he was providing an opinion as to his hearing of what was the audio portion of the video. Any objection to that?
No.
And that's
201.
no, I know that. There's also the recordings played to a jury 158
So I just,
covers that, which would cover that.
okay, I can put that in if you'd like me to. I think that it doesn't add much to anything, but I'm happy to.
I think
Okay.
it's redundant.
Yeah.
And what the jury needs to be instructed on is covered in 201. Or, yeah, 201.
Do you want 158 or do you want to just stand with 201?
No, I think it's. I was just pointing out it's essentially covered under 201, so that's fine.
Okay, so you're not requesting an additional one.
Right.
Okay, then I did put in opinion testimony. Again, I took out expert and I put in the hypothetical question because there were a couple of hypotheticals posed. I'll remove 327 because the defendant didn't testify. We had one witness with a prior conviction, but was the question ever asked if he had a prior conviction?
No, it wasn't relevant.
I didn't. I did not ask him.
And I don't think defense did either. So I'm going to take out 325. Is the defense requesting 315?
Yes.
Okay. 315 is in. I wasn't sure how the evidence would come in, whether or not 247 applied or not. And I'm thinking it does not, unless either side wants it.
I don't think it applies.
No.
Okay, it's gone. Then 300, credibility of witnesses, taking out the paragraph that would only have applied had the defendant testified. Burden of proof and presumption of innocence, closing arguments of counsel, closing instructions, then verdict submitted, and you'll see that I modified 484 to meet the lesser included, and that'll match the verdicts that are in your possession at this point. Then 515, unanimous verdict. Any additional instructions, state, or modification, state seeking?
No?
Defense?
No.
Okay, I'm going to print you each a fresh copy. It is 2:53. I think we have plenty of time left in the day.
I'm ready to go.
Awesome. Then I'm going to give you 7 minutes, and then we'll start at 3 o'clock with closing arguments. Do I need to set a time limit?
30 minutes would be fine for each of us, I think we discussed.
I do 45.
I'll give you each 45 minutes as a max to be utilized between initial and rebuttal. Fair?
Yep.
Okay, I'll print you fresh copies, and we'll start in 7 minutes.
Oshkosh, who also does work for the Wisconsin Department UW Oshkosh, who also does work for the Wisconsin Department of Justice. He talked about what he observed in terms of the bones and how Sade Robinson and her body may have been dismembered. He talked about blunt force trauma being used to crush many of the bones, and that it appeared there had been knife marks from a non-serrated knife used to cut through the flesh, which was at times cutting into those bones. That was the last state witness. The state rested. Immediately after that, the defense rested. They are not calling any additional witnesses beyond those they have cross-examined throughout the course of this trial. And so now it is time for jury instructions and closing arguments. And those closing arguments were set to begin in about 6 or 7 minutes. So we're going to be going back to the courtroom. I'm just leaving it up right now. You can see the clock on the wall. And so it'll be shortly after that that we're going to hear the summation from each side. They're going to make their best case. What are we going to hear? Well, let's talk about what we know, what we have learned over 8 long days in this criminal trial. We know that there's a lot of circumstantial evidence that points to Maxwell Anderson. We also know there is no direct evidence that connects Maxwell Anderson to a murder weapon or to a particular bloody crime scene. We did learn a lot more today, though, about the state's theory and what we're going to hear. We heard from witnesses who talked about everything from an ex-girlfriend talking about the secret beach, which happens to be the beach at Warnemount Park, where Sade Robinson's leg was found. She said that he had taken her there many times when they were dating, and they broke up back in 2023. We also heard today a lot of testimony from the forensic investigators and detectives who extracted data from Maxwell Anderson's cell phone, including those crucial photos that appear to show Sade Robinson face down, possibly asleep or passed out, we don't know, with her white sweater, and it appears to be a hand grasping her right breast. It appears to be on the very couch in the living room that we have seen from the photos that investigators took when they did the search warrant of Maxwell Anderson's home. We heard more about the timeline of what was happening with devices, including Maxwell Anderson's phone was shut down. It was not interacting with anyone or anything from 12:09 a.m. after the first date, so just after midnight. There were photographs that were deleted between 12:05 and 12:08, including those photos of Sade apparently on the couch. Then at 12:09, the phone stops interacting. There's no more interaction with a human until 9 a.m. or roughly 9 o'clock in the morning. We haven't heard each side's theory of what that means. We talked to Jonathan Lavoie of Kim and Lavoie earlier, who said the defense is probably going to try to argue that that is consistent with him being asleep at home, that Sade Robinson went home at 12:45, that she was fine, she was alive, she went back to her apartment, and then something terrible happened. And Maxwell Anderson was home the whole time, and then he picks up his phone and he texts her at 10 o'clock or 10:30 in the morning and says, "Morning, how's work going?" We did see that text message today. If that's the theory the defense goes with, there's a problem, and the state is sure to point it out. That at 7:30 in the morning, Maxwell Anderson was spotted near the scene of that car fire when Sade Robinson's car was set afire in the north side. So while his phone was not interacting, was apparently at home, he was up on the north side walking around the city, having walked away from the car fire and then getting on an MCTS bus and riding it back home. So if his phone was at home, why was he up on the north side near the fire in Sade Robinson's car? We expect to hear about that. Overall, bottom line, there's a lot of data that shows the movements of Sade Robinson's phone. Here's what we know, what seems indisputable. The two of them went on a date. They went to the Twisted Fisherman. They went to Duke's on Water. After that, it appears now pretty clear from all the evidence that's presented, although I'm not the jury and I'm not making a decision, but there's been an awful lot of evidence presented by the state that suggests they went back to Maxwell Anderson's home. And those pictures today seem to be the sealer on that she was on the couch in his home. We had other evidence that suggested that's exactly where her phone went, that's where her car went. Now we have the photos that show her on the couch. What happened after 12:45? That's the last time her phone is at that location, and then it leaves, and then it is traced for 4 hours circling around the city and eventually ends near Warnemount Park. We know her car busted through the gate. We know her car went down that service road and ended up down there for about an hour and a half before the car came back out and then went circling around the city again. Ended up on the north side, and then the car ends up being set on fire intentionally behind an abandoned property at 29th and Lisbon. We know Maxwell Anderson walked away from that car fire scene. We see him walking down the street with the backpack. We see him show up at the bus. We see him ride that bus back home and get off and go back to his house. That backpack's never been found. We do know that the day, though, he's walking around with that backpack, he's wearing a hooded sweatshirt. Prosecutors found that hooded sweatshirt in a garbage can 2 doors down from his house several days after all of this happened, and they found what was deemed to be a very strong likelihood that Sade Robinson's DNA was a very strong match of her DNA being on the pull-down zipper and inside the pockets and on a sleeve of that coat. How did that get there? Was that something that happened on the date? Was it something innocuous? All we know is, for some reason, it was thrown away in the garbage 2 doors down, and it had Sade Robinson's DNA on it. There was no DNA found at any sort of bloody crime scene. No bloodstains that came back to Sade Robinson. There were bloody gloves found along the beach that turned out to have nothing to do with the case, which you might even ask, why did the state keep bringing it up? Well, it may be that the defense planned to use that as some sort of a diversion to say, look, these gloves don't even belong to Maxwell Anderson. They have somebody else's blood on them altogether. The state seemed to diffuse that by calling it out and saying, you're right, these gloves were irrelevant. They had nothing to do with this case to begin with. In the end, we don't know for certain who was in that car driving around because the windows were foggy and you couldn't see inside, and prosecutors never got a good look at who was behind the wheel from 12:45 in the morning until 6-something when it's driving around the north side and eventually it's set on fire. We do know that Sade Robinson ended up dead, dismembered, her body parts found all along Lake Michigan shoreline, all the way down to Illinois and in parts of northern Milwaukee near where the car was set on fire. We know there's a ton of evidence showing that Maxwell Anderson was connected to her in many ways. In the days leading up to this, they were actually out together at Victor's nightclub 2 nights or 3 nights before all of this happened. And then, of course, went on this date that was deemed by everyone to be a first date together. Whether it was or not, we don't know for certain. In the end, the jury's going to have to look at all of that and make a determination. Is there a reasonable explanation other than Maxwell Anderson? Is there even enough doubt that a reasonable person could go, you know, the defense makes a good point. There's another theory here. We don't have a murder weapon. We don't have a bloody crime scene. And while there was that screenshot deleted from the phone that said something about what doesn't mix with bleach or what shouldn't you mix with bleach, The judge just said, as she was going through making her determination, could a reasonable jury find him guilty in the light most favorable to the state? She pointed out that very thing, the bleach screenshot, saying that looks like it could be evidence of someone looking up information on how to cover up a crime. So if a jury looks at all of that, can they say there's another theory that makes sense? Did she go home? Was Maxwell Anderson, did he just happen to be in the wrong place at the wrong time where the car fire happened? Or was that not Maxwell Anderson at all? Is it a misidentification? It seems like the defense has a long way to go here. We hear Maxwell Anderson is back in court now, so I imagine we're going to be coming back on the record soon. Closing arguments are about to commence, and it is possible, it sounds actually likely, that the jury may have this case by the end of today, unless for some reason this has to stretch into tomorrow. Each side has been given 45 minutes to deliver its closing argument, so that is going to pretty much close out this Thursday, and then if there is more to go on tomorrow, it may be tomorrow morning when the jury officially gets this case and begins deliberations. But obviously, we're going to keep it right here. We are right here on the Wisconsin Live Desk, and again, we'll be here until 4 o'clock. In the middle of closing arguments, one of these streams, depending on which stream you're watching right now, one of them is going to switch over to Fox 6 News at 4. But you can get the uninterrupted testimony on our Fox 6 News Milwaukee YouTube channel. So if you're watching and it switches over to the news and you want to keep watching testimony, go to YouTube, go to the Fox 6 News Milwaukee YouTube channel. You can watch all of those closing arguments there. So I'm hearing now, Bria Jones is reporting that the jury is about to come back in. As soon as the jury is back in and in place, we're going to be taking you back out to the Milwaukee County Safety Building, room 620, as we get prepared for closing arguments. This is the 8th day of the trial. It is the 7th day of testimony. We have heard from 62 distinct state witnesses, 84 witnesses in all. Many of them called several times.
Okay, we are back on the record.
Judge.
Could all
Let's
of you
head back
pass
out
your
to the safety
notebooks
building.
down towards Deputy Benz, please. So when you were last here, the state rested, subject to rebuttal. Does the defense intend to present any case?
No witnesses, Your Honor.
Then at this point in time, I'm deeming the evidence closed. So here's the plan for the afternoon. It is 3:05. I'm going to read to you the instructions, and then we're going to go into closing arguments. I've set time limits because I think it'll help on this case. So each side will have in total a maximum of 45 minutes to utilize during their closings. That's going to get us pretty close to 5 o'clock, and then we'll come back tomorrow for deliberations, okay? So, members of the jury, I will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdicts. It is your duty to follow all of these instructions. Regardless of any opinion that you might have about what the law is or ought to be, you must base your verdict on the law that I in these instructions. Apply the law to the facts in this case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law that I give to you in coming to your conclusions and your verdict in this case. If any member of this jury has an impression of my opinion as to whether the defendant is guilty or not guilty, you should disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and I am the judge of the law only. Now, the first count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, did cause the death of Sade Robinson, another human being, with the intent to kill that person, contrary to Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The defendant in this case is charged with first-degree intentional homicide, and you must first consider whether the defendant is guilty of that offense. If you're not satisfied that the defendant is guilty of first-degree intentional homicide, you must consider whether the defendant is guilty of first-degree reckless homicide, which is a less serious degree of criminal homicide. Now, the crime referred to as first-degree intentional and first-degree reckless homicide are different types of homicide. Homicide is the taking of the life of another human being. The degree of homicide is defined by the law, depends on the facts and circumstances of each particular case. Both intentional and reckless homicide require that the defendant cause the death of the victim. First-degree intentional homicide requires the state to prove that the defendant acted with the intent to kill. First-degree reckless homicide requires that the defendant acted recklessly under circumstances which showed utter disregard for human life. It is for you to decide of what type of homicide the defendant is guilty, if guilty at all, according to the instructions which define the two offenses. Now, first-degree intentional homicide is defined in 940.01 of our criminal code and is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. One, that the defendant caused the death of Sade Robinson. Cause means that the defendant's act was a substantial factor in producing the death. Two, that the defendant acted with the intent to kill Sade Robinson. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive by itself does not establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you're satisfied beyond a reasonable doubt that the defendant caused the death of Sade Robinson with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you're not so satisfied, you must find the defendant not guilty of first-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide in violation of statutory section 940.02 sub 1, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. Now, as I already stated, first-degree reckless homicide is defined in 940.02 sub 1 of our criminal code and is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. One, that the defendant caused the death of Sade Robinson. Cause means the defendant's act was a substantial factor in producing the death. Two, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means that the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all the other facts and circumstances relating to the conduct. Consider also the defendant's conduct after the death, to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time that the death occurred. If you're satisfied beyond a reasonable doubt that the defendant caused the death of Sade Robinson by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life, you should find the defendant guilty of first-degree reckless homicide. If you're not so satisfied, you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of these offenses. Now, the second count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024 in Milwaukee County, Wisconsin, did dismember a corpse with the intent to conceal a crime, contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Section 940.11 sub 1 of our criminal code is violated by one who mutilates, disfigures, or dismembers a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. One, that the defendant dismembered a corpse. Two, that the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, statements, if any, and from all of the facts and circumstances in the case bearing upon intent. If you're satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. Now, the third count in the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, at 2926 West Lisbon Avenue in the city of Milwaukee, Milwaukee County, Wisconsin, by means of fire, did intentionally damage the property other than a building of Sade Robinson, valued at $100 or more without that person's consent, contrary to Wisconsin statutes. To this charge again, the defendant has entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Arson is defined in 943.03 of our criminal code and is committed by one who, by means of fire, intentionally damages any property of another without that person's consent if the property is not a building and has a value of $100 or more. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following five elements were present. Number one, that the defendant intentionally damaged a 2020 Honda Civic by means of fire. Damage means injured, charred, defaced, and includes smoke damage. Intentionally means that the defendant must have had the mental purpose to damage the property of another by means of fire, or was aware that his conduct was practically certain to cause the damage to the property. The second element is that the 2020 Honda Civic was the property of another. Property of another means property in which a person other than the defendant has a legal interest, which the defendant has no right to defeat or impair, even though the defendant may also have a legal interest in the property. The third element is that the defendant damaged the property by fire without the owner's consent. The fourth element is the value of the 2020 Honda Civic was $100 or more. And the fifth element is that the defendant knew that the 2020 Honda Civic belonged to another person, and that the other person did not consent to the damage of the property, and that the value of the property was $100 or more. Again, you cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case which bear upon intent and knowledge. If you're satisfied beyond a reasonable doubt that all five elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The fourth count in the information charges that Maxwell Anderson, on or about Tuesday, April 2nd, 2024, in Milwaukee County, Wisconsin, did hide a corpse with the intent to conceal a crime contrary to Wisconsin statutes. To this charge, again, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 2 of our criminal code is violated by one who hides or buries a corpse with the intent to conceal a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. 1, that the defendant hid a corpse. 2, that the defendant hid a corpse with the intent to conceal a crime. Can't look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case bearing upon intent. If you're satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. Now, evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who calls a witness. Second, the exhibits the court receives, whether or not they go to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which I've directed you to find. Anything you have seen or heard outside of this courtroom is not evidence. You are to decide this case solely on the evidence offered and received at trial. Disregard entirely any question that I did not allow to be answered. Do not guess at what a witness's answer might have been. If a question itself suggested certain information might be true, ignore the suggestion and do not even consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusion from the fact that an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, I am not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and of the weight of the evidence. During the trial, I have ordered certain testimony to be stricken. Disregard all stricken testimony. Remarks of the attorneys are not evidence. If a remark suggested certain facts not in evidence, disregard the suggestion. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after an alleged crime was committed. Whether the evidence shows consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, a witness may only testify about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which an opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. The identification of the defendant is an issue in this case, and you should give it your careful attention. You should consider the reliability of any identification made by a witness, whether made in or out of court. You should consider the credibility of a witness making an identification of the defendant in the same way you consider credibility of any other witness. Identification evidence involves an expression of belief or impression by a witness. Its value depends on the opportunity the witness had to observe the offender at the time of the offense and later to make a reliable identification. Consider a witness's opportunity for observation, how long the observation lasted, how close a witness was, the lighting, the mental state of the witness at the time, the physical ability of the witness to see and hear events, and any other circumstances of the observation. You should also consider the period of time which elapses between a witness's observation and the identification of the defendant, and any intervening events which may have affected or influenced the identification. In evaluating the identification evidence, you are to consider those factors which might affect human perception and memory and all the influences and circumstances relating to the identification. Then give the evidence the weight you believe it should receive. If you find that the crime alleged was committed, before you may find the defendant guilty, you must be satisfied beyond a reasonable doubt that the defendant is the person who committed the crime. Ordinarily, a witness may testify only about facts. However, in this case, Detective Casey Donahue was allowed to give an opinion as to what he heard on a video-audio recording. In determining the weight you give to this opinion, you should consider the witness's opportunity to observe what happened and the extent to which the opinion is based on that observation. Opinion evidence was received to help you reach a conclusion. However, you are not bound by the opinion of any witness. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it was based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on a witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of the trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or the lack of clearness of the witness's recollection, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you, and you should do the same thing here. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs in life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions that I have given to you. State, are you prepared to proceed?
Yes.
Please do so.
Ladies and gentlemen, at the beginning of this trial, I told you that I was going to ask you to do two things then. I'm asking you to do the same two things now, and to use your common sense and search for the truth. That is what the bulk of those instructions are telling you to do. You have heard all of the evidence in this case. You have heard from dozens of witnesses. You have seen hundreds of images, watched stacks of videos. You are fully equipped to determine what the facts are, what it is that happened on April 1st and April 2nd. All of that information has rendered you capable of rendering fair and rational verdicts. And the judge has instructed you on the law, and shortly, probably not today, but when you come back tomorrow, it's going to be your time to let your voice heard after hearing everything that you have heard. On the night of April 1st, 2024, into April 2nd, 2024, Sade Robinson was murdered. She was taken to Warnemont Park, cut into pieces, dispersed mostly into Lake Michigan, her car taken to the north side of Milwaukee, and burned behind an abandoned building at 30th and Lisbon. And the evidence in this case has shown you beyond a reasonable doubt that the individual responsible for those intentional acts is Maxwell Anderson. This is my opportunity to summarize the evidence for you, and I'm going to do it in kind of essentially the form of a timeline on the TV screen here. So we'll start out with Sade's day. And Sade Robinson, she was a 19-year-old young woman just coming into adulthood. She was anything and everything that any 19-year-old would want to be. She worked a job. She worked 2 jobs. She went to MATC. She was supporting herself. She had her small Lower East Side apartment, modest. And most of all, she was loved and respected by her family. She was fun, social, and clearly anybody knew her, cared about her deeply, until she came into contact with 33-year-old Maxwell Anderson. At 9 a.m., April 1st, Sade left her apartment at 1858 North Commerce Street. She is wearing the last clothes she would ever wear, that white cable knit top, the black puffy coat, the ripped jeans, and the white shoes. And she went to work at Pizza Shuttle. She arrived at Pizza Shuttle over there on North Farwell Avenue on the Lower East Side around 9:15 a.m., and she worked her shifts just like any other day of her life. Beginning around 4:15 p.m., she began texting with Maxwell Anderson. They had met the previous weekend at Victor's. You saw the video of her going into Victor's and then him walking her out, and it's clear that they were intending to meet up that night. And Maxwell Anderson says, why not Twisted Fisherman? And this text conversation begins around 4:15 p.m., and they agree to meet there shortly after 5 p.m. We know from the cellular records where each of them are at those times. Maxwell Anderson is over at his house on South 39th Street, and Sade is up here at Twisted Fisherman. When her shift is over, she goes to meet him at the Twisted Fisherman. Maxwell Anderson takes an Uber ride. Sade leaves work at 5, and the phone information shows them both moving towards the Twisted Fisherman right around the same time. And we know that Maxwell Anderson walks in to the Twisted Fisherman at 5:09 p.m. wearing that black Carhartt shirt that would later be found in his laundry, and the red plaid jacket that police found inside Maxwell Anderson's house that you know has Sade Robinson's DNA on it and Maxwell Anderson's DNA on it. 5:11, 2 minutes after he gets there, he sits down at the bar, he sends a text to Sade, just got to Twisted. Sade arrives around 5:20. We know that from about 5:20 p.m. to 6:24 p.m., the two of them sit at Twisted Fisherman. They eat, they have some drinks. They both take shots. In fact, at one point, Sade turns down a shot, but they're just hanging out. And after 6:24 p.m., the two of them leave Twisted Fisherman together. They walk out and they walk together to Sade Robinson's 2020 Honda Civic that she has driven there. Sade drives the two of them from Twisted Fisherman to Dukes on Water. We know they traveled to Dukes on Water between 6:24 p.m., arriving there just around 6:33 p.m., And you saw the video of them parking. Sade, again, driving, Maxwell Anderson riding passenger, just the two of them. They walk into Dukes on Water at 6:36 p.m., consistent with the phone information showing them arrive at Dukes on Water at 6:36 p.m. At 9:03 p.m., actually, I'll go back up. They stay there. They hang out right here. Maxwell Anderson is drinking. He's having multiple drinks. Sade's got a couple drinks. Mr. Anderson takes it upon himself to play a few games of bar dice, and he takes several shots. But at no point at any time when they're at Twisted Fisherman or Dukes on Water is Sade Robinson doing anything that comes close to excessive drinking or anything like that. In fact, when you watch her on these videos, she is totally coherent. She has her wits about her. When they leave at 9:03 p.m., she's fine. They walk out together. She's not stumbling. She's totally fine. They walk together to her car. She gets in the driver's seat and he gets in the passenger seat, and it's just the two of them who leave the bar together. And ladies and gentlemen, this video right here that's playing on the screen and the surrounding videos that watch Sade going into her car, this is the last time Sade Robinson was in public with anybody else. That young lady who's in Dukes, who she gives a hug to at the end of the night when they're leaving, that's the last person other than the defendant who she was with, who she had contact with. That's what the evidence shows. After this time, they leave, and we know exactly what route they took. Through the videos from downtown, they drove Sade Robinson driving, Mr. Anderson riding passenger. They take McKinley up. They get on the interstate. They drive to the south side. This is occurring from 9:04 to 9:14 p.m. By 9:14 to 9:25, they're getting off the interstate, heading westbound on Morgan Avenue. It's the Holt Avenue exit, but it's Morgan Avenue to the west of the interstate. And they go and they arrive at his residence just around 9:20 to 9:25 p.m. That's what the phone records confirm. And that is what the videos, here's one of them from around Sade's residence, show as well. You had the videos of them pulling into the alley. All of this confirming, by the way, that Sade Robinson's phone is essentially wherever her car is that night, right? It's at Pizza Shuttle when she's working, it's at Twisted Fisherman when she's there, and it goes back to her with Maxwell Anderson after they leave Dukes. And they don't stop anywhere. Remember that. When they leave Dukes, they don't stop anywhere. It's a continuous trip on that Life 360 app from Dukes to Mr. Anderson's home, and they arrive there at 9:20 p.m. And we know that after 9:20 p.m., 9:23, this is that really small video that shows them coming into his backyard at 9:24 p.m. She has parked her car in the alley, just the two of them, and they come inside at 9:24. And by 9:25 p.m., they are upstairs. That motion light is on. And you heard from the detective who watched this video for hundreds of hours. You saw a lot of the clips from here overnight, some of them pretty cumbersome. But what did that establish that happened? It established that they were both there in Maxwell Anderson's apartment. And there is constant movement coming from that upstairs front window, starting at 9:25 p.m. when they're up there and going essentially on and off all the way up until 12:45 a.m., at which time all movement at that house, in that front window, and in that backyard by that back gate stops. What else happens in that time? You see movement beginning at 11:24 p.m. in the side yard. Here's the slide that shows their phones remaining there, corroborating what the video shows of her car arriving there as well. At 11:25 p.m., we see that movement in the side yard beginning. Then there's movement again after 11:25 p.m. on and off in that above front room. 12:05 to 12:08 a.m., what do we know is happening? We know that Maxwell Anderson is on his phone, traversing his photo gallery, where he has, by 12:05, already acquired pictures, already taken pictures of Sade Robinson incapacitated on his couch. She is face down. Her face is buried in his couch cushion. He has her breast exposed, and he is grabbing her right breast, the breast that would later be cut off of her body, and pulling her pants down. And you know from the search warrant of the house, this right here is that brown ottoman. This right here is the red couch. Between the movement in that front window and these photographs, you know that Sade Robinson became incapacitated while she was in that front room of Maxwell Anderson's house, laying on his couch, face down. She is out of it there. Out of it. He is grabbing her because he knows he can, because she's not going to do anything about it. She has no power. You can see that in those photos. Her face down in the cushions. 12:44 a.m., this is the last movement in that side yard. And if you recall, I made it a point to ask about the two blinking lights from her car, the Honda Civic. You saw it in the video from when they left Dukes on Water, and you see it in this video from across the street. It's faint, but it's there. This is the time, ladies and gentlemen, where Maxwell Anderson is removing Sade's body from his house, taking her to the car. It's now time to get rid of her, and he's got to do it in her car. He needs the car away from his home. He needs to get rid of anything that's going to tie her back to his home. He needs that car gone. He needs her gone. 12:47 a.m. is when we see the car leaving the house, going southbound, exiting onto Euclid, and from there you saw an exhausting amount of videos showing the car driving away from his house, northbound to the north side of Milwaukee. That was 12:49, 12:51 going northbound on 35th Street, passing Badger Ham, 12:53 a.m. northbound, passing 35th and Greenfield, and eventually we get the exact route that is taken when we get the phone records. He drove northbound on 35th, he went to the downtown area, and he ultimately exited the interstate just prior to 1 o'clock a.m. Remember, this timestamp was off by about 2 minutes and I thought it was 2 minutes, 40 seconds or so that the detective said. That is her car. We know it's her car because this camera happens to have a license plate reader. And that license plate reader is putting her on that exit ramp downtown at the exact same time that her phone, her Life 360 and Verizon records show that car would be exiting at that same time. What can you conclude from that? You can conclude that her phone is in that car. She's in that car. Someone's driving that car. It's Maxwell Anderson. Continues to drive. He goes up Commerce, passes by her apartment building. I know something of defense was trying to make some note of it. They never stop at her apartment building. There's no evidence that happened whatsoever. And the detectives reviewed hours and hours of video footage from her apartment building to ensure that car never came back and that Sade never came back to the apartment. He didn't stop there, and these records confirm that. What does he do? He drives the car with her body up into the River West area by about 1:33 a.m. There he is at 106, driving her past Commerce Street, passing Lakefront Brewery. And then he heads into River West. You saw the video of the car in River West off of Dowsman near Pleasant Valley Park along the Milwaukee River. And what do we know happens while he's out and about driving around? His phone dies. He leaves his phone behind. That was done on purpose. Because look at all the records we have showing where her phone traveled and where his phone traveled before this time. He left it behind to cover up. That's why he did that. And we know that because we looked at it, and you heard from the analyst today who said that all activity on that cell phone stopped after 12:08 a.m., right after he's deleting pictures of Sade Robinson on his phone, of him grabbing her. Phone dies at 1:35 a.m. while he's driving her car around trying to get rid of her and trying to get rid of the car. He goes down Capitol. You saw the two videos showing the car going down Capitol. He doubles back towards the interstate. And by 2:20 to 2:25, he's back on the interstate heading back towards downtown. He eventually goes down through downtown on Interstate 94, ends up heading sort of west over to Greenfield, and then he comes back. And where do we know that he's heading at this time? He's heading to Warnemont Park. The phone records show that between 2:34 and 2:39, he's on the interstate, getting off on College Avenue. We saw the video of him exiting on College Avenue, and you saw the video of the car going through the airport tunnel in the direction of Warnemont Park. No stops being made, by the way. 2:51, he's passing by St. Luke's Hospital, going north on Lake Drive, all in an effort to ultimately end right here, Warnemont Park. Keep in mind what Agent Reiners testified to, the 4 dwellings that Sade Robinson's Life 360 showed. There were 4 of them. Twisted Fisherman, her own work, or excuse me, Twisted Fisherman, Dukes on Water, Maxwell Anderson's house, and Warnemont Park, where she ends up. And her phone stays there for over 2.5 hours. Excuse me, an hour and a half. 2:52 is the arrival time, 4:33 a.m. That's the time the phone is there. We know at 2:52, her car is passing by the water department. And by 2:53 a.m., this was one of the first videos we saw, there's the Honda Civic going down Pulaski Avenue, going down the service road and ramming the gate to get down that service road, that steep road that you saw a photo of today when Chloe Wright was testifying. Why ram the gate? He knows how to get down there without ramming the gate. You saw a photo of the place, the way that they would walk down. You ram the gate because there is a body in the car that you have to get rid of, that you can't carry. He rams the gate. We know it's using her car because the crime lab fitted the broken pieces of Honda back to her vehicle. No question about whose car was used to ram that gate. It was Sade Robinson's Honda Civic. From 2:52 to 4:30 a.m., like I said, the phone remains in that location. What is that location? That is Maxwell Anderson's secret beach. It's the place of all the places in Milwaukee County to go. Of all the places to go, Sade's body ends up at his secret beach. He chose that location on purpose. You heard the reasons why today. It's secluded. He didn't even want to tell Chloe Wright what the name of the place was. He wants to keep it to himself. And you've seen the photos of it. You've seen how high those cliffs are. This is the middle of the night on a Monday into a Tuesday in a rainy early April evening. No one's going to catch him in the act. It's pitch black down there. It's the perfect place in his mind to take her to accomplish this. Because he knew he had work to do. He needed to cut her up and get rid of her. So he takes her to a place he knows and a place he trusts. A place he knows he's not going to get caught. You saw the videos of the person who we now know as Maxwell Anderson ascending and descending the bluffs on the north side of the pump house, the side where her leg would later be found on April 2nd, going up the exact paths that Chloe Wright told you they would take to go down there and hang out. The exact paths. This is the time, ladies and gentlemen, where he is cutting up her body. She is dead. Now it's time for him to get rid of her. So that's where he goes. He takes her to his place. You saw in the video when he's coming up the bluff at 4:26 a.m., he's down there for over an hour and a half. And in that time, you heard gruesomely all that was done to Sade. All the cutting. The blunt force trauma to her bones. All of it done to get rid of her, to make her disappear. That's what he wanted to do. That's what he tried to do. And he did it in this time frame. From about 3 a.m. when he got there to 4:30 when he left. Now it was time for him to get rid of her car. So what does he do? 4:34, he drives her car out of Warnemont Park. We know he heads northbound on Lake Drive. We know that because Sade's phone is still in his car. Here's the record showing the direction of travel. From the site where the leg is found, her body is dispersed, headed northbound on Lake Drive, westbound on Howard Avenue here until the phone goes off the network. There's the video of him going by. And there's the last clip before it gets to the north side. And by 4:50 a.m., it is at 27th and Wells where you can see the driver is a white person. You can see that in this video, and you can see how fogged up it is, and you can see how there's something covering the back window. He then drives north, circles the area of 32nd and Vliet, tries to go down this dead end near 34th and McKinley, but activates a ring light, so he decides, I gotta go to a different place than this. There's no reason for him to drive down that street. Circles around until about 5:20 a.m. when he goes off camera and reappears at 6:50. And it is at this point, ladies and gentlemen, that he is in the 31st and Galena playground. This is the area where her leg is found, her left leg. That gap shows that during that time period, he went into that playground to dispose of her leg. By 7:30 a.m., you saw the video of him walking away from the burning car, where we now know from the crime lab he used an ignitable petroleum distillate to light the car on fire. And he walks away. And the trail of videos capture him walking southbound on 30th. He goes down Walnut Street. Trail of videos captures him all the way at 8:12 when he boards a Milwaukee County Transit bus, where his face is clearly visible, clear as day, and he's wearing a hoodie, that gray hoodie that would later end up in a dumpster 2 houses down from his. Tried to get rid of it, but he didn't. They found it. And whose DNA is on the hoodie? That is not the hoodie he's wearing on the date, by the way. That's the hoodie he's wearing after he has just dismembered a body and burned a car. And whose DNA is on it? His and Sade's. What are the chances of that? It's because he did it. It's because he's responsible. And he takes the bus home. He sits there, not a single time pulling out his phone. Why? Because he left it back home on purpose. And then by 8:42, walking in his back gate with that massive backpack that we have never found. He got rid of it. And whatever else was in it and whatever else was used, he tried to get rid of everything. He tried to cover up. And what does he do after he gets home? He powers up his phone and he sends a text. Morning, how's work going? Disgusting. Right after he's just burned her car, killed her. Why did he do that? He's covering up. He's trying to cover his tracks. He's trying to make sure everything seems normal. Same reason he went to work that day. Couldn't let his routine go out. He needed to maintain appearances, despite the fact that in the middle of the night, he's out cutting up a human body and burning a car. And by 5:29, Sade's leg is found on April 2nd. By 9 p.m. that day, she's reported missing and the welfare checks begin. By 1 p.m. on the 4th, Mr. Anderson's arrested. And we know that in the subsequent days and month later, April 18th, May 11th, additional body parts are found. Her head, her right breast have never been found. He succeeded in getting rid of those. That's what happened. Those are the facts. That's what the evidence showed. Now you have to decide, based on the law, given to you the crimes. I want to focus on the homicide count. There's 4 charges. Numbers 2, 3, and 4 are pretty self-explanatory, and you have them in writing. Mutilating a corpse, hiding a corpse. Counts 2 and 4 are essentially the same elements. Count 3, the arson, pretty self-explanatory. But now you're given this first-degree intentional as well as first-degree reckless homicide. First-degree intentional homicide has 2 elements that I have to prove. I have to prove that the defendant caused the death of Sade Robinson and acted with the intent to kill. While the law requires that he acted with the intent to kill, it does not require that that intent exists for any given period of time. In fact, it says it may be formed at any time before the act, including the instant before the act. And you're also instructed that intent should not be confused with motive. While proof of intent is necessary, proof of motive is not. Motive being the reason why someone did something. That's not what we have to prove. We have to prove intent. And only if you don't all agree that he is guilty of first-degree intentional homicide, which I'm confident you will, do you even look at first-degree reckless homicide. The defendant caused the death of Sade Robinson, caused the death by criminally reckless conduct under circumstances that showed utter disregard for human life. Did he show any regard for life at all? No. So how do we know this was intentional? Everything you heard shows this was intentional. Consider all the things he intentionally did and the reasonable inferences from those actions. At 9:25 p.m., when Sade drives him and herself to his house, just the 2 of them, they went inside, and we know from before that she is coherent. She is not drinking excessively. She's in control of herself. But by 12:05, she is completely incapacitated, face down on his couch. And Anderson is grabbing her exposed right breast with no reaction from her whatsoever. He's pulling her pants down, taking photos while doing these things. This shows she was completely incapacitated, if not deceased, by that time. Consider all the acts to this point. He has her at his house, on his furniture, completely deprived of any strength or power over herself. He's then taking pictures and then intentionally takes her car and her and drives her away because he's now got to get her out of there, and he has to separate himself from her and her car. He drives with seemingly minimal direction, leaves his phone behind, brings with him a huge bag, some kind of a tool to cut up the body, takes her to a place he knows well. All done in the middle of the night. He takes her to Warnemont Park, cuts her body up, drives away, goes to the north side, goes to the 31st and Galena playground, discards her leg. He intentionally picks an abandoned building to leave her car behind, something that he has no connection to. Intentionally stuffs her clothing that she is wearing that night. The underpants literally pulled off of her body, still in the jeans when they're found partially burned in her trunk. Stuffs her clothes in her trunk. Uses a petroleum distillate to light the car on fire. All of that stuff was done on purpose. He then heads home, powers up his phone, and texts her. Everything about this is intentional. If it was unintentional, if it was anything else, you don't cut her up and do everything you can to get rid of her. If it was an accident, you get her some help. You don't try to make her disappear. And we know from the medical examiner, there is no other explanation. There was no natural disease, no toxicology reason whatsoever for this. If it was unintentional, he wouldn't have had the wherewithal to do everything he did so quickly. Think about it. In just hours, she went from literally driving a car to being incapacitated and him somehow being able to pull off, getting her to Warnemont Park and cutting her up. He's only able to do that if he knew what he was doing, knew how he wanted to do it. This only happens with the intent to kill. Consider what Dr. Karsten today and the medical examiner talked about, the amount of work done to break her bones and cut up her limbs and cut off her head. The efforts to cover this up were extraordinary and they were horrific. Consider the cutting off of her breast, her right breast. That's not something you do unless you have a desire to do it. It doesn't facilitate getting rid of the body. It takes additional time. He did it because he wanted to do it. All the stab wounds near her breast and on her torso. That was done out of a sick desire to do harm to her. That's the only reason that is done. Cutting off the breast, dismembering limbs, beheading her. Those acts, simply put, ladies and gentlemen, are the acts of a killer. They are not the acts of someone who is acting on impulse in a moment or acting on emotion. Who does this? What kind of person cuts someone's head off? A killer. A killer who's trying to get away with killing. His actions afterwards betray any innocence. That's how the evidence shows that what Maxwell Anderson did to Sade Robinson was an intentional homicide. There is no question behind the intent, and there's no question about the person responsible for doing it. The killer is him. He's the last person to be with her, the last one texting her, the last one whose residence she was at, the last one who had her car, the last one who had her phone, the last one who was with her. The one who burned her car. He did everything he could to try to get away with it. He tried to cover up. He tried to fool the police. He's trying to fool all of you, but he doesn't get to do that. You've all seen the evidence. It's time that you let the evidence speak the truth and you find him guilty.
If you watch this with me, you know I don't think highly of any lawyers on either side because they were all stupid to me, but he is giving a great, outstanding closing statement. Like, it's beautiful. He's laying it all out. He's lining it all up. I got more faith in him with this closing statement. But earlier throughout the trial, I didn't think he was so great, but how he summoned this all up, he's great at his job.
Guilty.
Defense?
Look at that. Motherfuckers is clapping. He summoned that shit up real good. I ain't gonna lie. He summoned it up great.
I'm going to take that down then. Or just close it. Good afternoon, everyone. Wanted to start by telling you what the purpose of closing argument is. It's, of course, my chance to speak to you. This is my last chance to speak to you as jurors. I don't get a rebuttal. The state does, so they still have an opportunity to come up here and speak to you again. This is the only opportunity that I have, and so I just wanted you to be aware of that. When I got up here in opening, it feels like ages ago now, it was 2 weeks ago when I stood up here and talked to all of you, and you've listened to a lot of testimony, I asked you to keep an open mind and to study the evidence closely. And I'm going to make the same request of you here today, tomorrow, when you deliberate, to study the evidence closely. You've been given a mountain of materials, and the judge has read a lot of instructions to you, and I want to talk a little bit about those instructions because as you hear Judge Crivello reading the instructions, it sort of goes on, but you're going to be given copies of those to take back with you to study closely and examine. And I ask that you look at those closely and pay careful attention to everything you heard in this case. The most important principle in the criminal justice system is the idea that a person can only be convicted if the district attorney's office has proven a case beyond a reasonable doubt. That principle has been with us for hundreds of years since the country was founded. The reason why that principle is so important is because it's crucial that when somebody is charged with the most serious of crimes, that we have absolute proof beyond a reasonable doubt by the district attorney's office that when they decide to bring such serious charges against a person, that you are convinced beyond any reasonable doubt that in fact Mr. Anderson committed each one of these crimes. When Judge Crivello spoke to you, she talked about what reasonable doubt means. Reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. So you can look at evidence as well as lack of evidence. It means such a doubt that would cause a person of ordinary prudence, meaning any of us, to pause or hesitate when called upon to act in the most important affairs of life. And of course, this is the most important affairs of life because you are deciding Mr. Anderson's guilt on, or whether he's not guilty on each of the counts. Another important instruction that the judge had read is that each verdict, each count in this case, requires a separate analysis. And when I listened to the state's closing, I heard a lot about what their theory is with respect to intentional acts that they believe were committed after Sade passed away. I heard a lot about intentional acts that that Mr. Vance Cruzan talked about in open.
Sorry about pulling that up on the screen. I was just trying to see if I could change the title to closing arguments. I'm sorry.
And again here in closing. But I want to emphasize that when you go back to the jury room and you evaluate the evidence, you are required to evaluate each count separately. And what the judge told you, what Judge Crivello said when she read the instructions a little bit ago, is that your verdict for the crime charged in one count must not affect your verdict on any other count. Why is that important? It's important because this is a highly emotional case. Obviously. We all know that. We all know that it's that type of case. And we'll just call a spade. I mean, we have a victim's family sitting right here. We just heard them applause when the state finished their argument. I don't criticize them at all, what they're going through. It's not at all what I'm here to do. I can't even imagine it. Can't imagine it. But here's how the system works. We get 12 jurors together. We have 15 of you here, and you've been amazing jurors, all of you, here on time, ready to go, listen to everything. And what we try to do when we're representing somebody and representing Mr. Anderson is we try to pay attention to what's happening in court, but also all of you, because your decision is what really matters. It's not what Mr. Vance Cruzan says. It's not what I say. It's really what all of you say once you go back in that jury room and carefully consider the evidence or lack of evidence. And it's important to evaluate each one of these counts separately. And the judge told you, as hard as that can be in cases like this, to try to check your emotions at the door. I know it's hard. I don't think any of us envy any of aspect of what our jobs are. We all have a job to do. The most important job is yours. And it's to check your emotion at the door, put aside passion, put aside prejudice, and look at the case from the evidence. That's all I ask you to do. And on each count, render a...
Bro, the evidence is overwhelmingly that your client did it. Facts.
Separate verdict. Unanimously. All of you agree. And there's a number of things I could say to you. The idea here is that each side is given 45 minutes. I don't know if I need 45 minutes when you've sat here and heard everything the same way I've heard everything, the same way the state has heard everything.
Look, he's telling the jury that, hey, man, I got 45 minutes, but I really don't need 45 minutes because I don't give a fuck about this client. I know y'all know he's guilty. Like, I'm just saying there's no passion from him. There's no passion. When you on trial or you on a jury trial, 'cause I've been to court before, the jury has to believe your lawyer. The jury has to see you, like you, and believe in you. Even though you sometimes don't testify in your own case, but they have to like you. They have to like your lawyers. And when your lawyer's up there like, oh, I don't even need the whole 45 minutes. You seen what I seen. Yeah, I seen that he's guilty, bro. You suck.
We try to look at the jurors to see some people are taking lots of notes, some people are taking less notes. And at the end of the day, really, it's just what you remember and what you ask to see. That's what counts. And you can ask to see anything. You can make a request when you go back there of the judge to view videos again, if that's something that you'd like to do, or look at DNA reports or look at photographs. You can make those requests, and I would encourage you to do so. And so I'm going to touch on some of the points that I think are important. You may agree with me, disagree with me, but this is my chance to present to you what I think are the important points in Max's defense. We do have separate crimes that are charged here. Obviously, if we broke them into sort of broad categories, there's the state's theory that Max intended to kill Sade Robinson. So that seems to be the glaring charge, of course, that is here. We also have charges of dismemberment, hiding a corpse, and arson of a vehicle. I'm not going to go through each of the elements of every one of these crimes with all of you because that will.
Once again, like I always say, I just started doing lives. I never did lives before, and I chose this case. And, you know, I don't get nobody 3 people, 4 people, 5 people. It's okay. I'm going to keep grinding it out. But if you 3 people, 4 people, 5 people, just push the like. It's not going to kill you. I don't want to call you a content stealer because that's what people do. They'll come to people's lives and come to people's channels and watch the video and don't give them a like. Don't sit there like, that's how we grow bigger, by likes. That's how we grow bigger and get more people into the room, by sharing. So, you know, if you like the trial, you like watching it, I shut up for the most of the part. Sometimes I even leave. I don't, like earlier, I went to the grocery store, left it on. Just hit the like button. You ain't got to like me. You like what you watching. Hit the like button.
We'll go back with you to the jury room and you can read those and decide. But we start with the fact that everything the state showed you in this case was that Max had met Sade. You saw the videos that were just played again in closing. The 2 of them met each other, and the 2 of them went out in public. They texted, they made arrangements to go out, and they went to places. When you watch the videos, they went to places that Max is known. Places where he was interacting in a friendly way with bartenders, where people were talking to him on a first name basis, where he's shaking hands with people, where he's having normal drinks, normal behavior. They go to Twisted Fisherman. They spend time there together. There's nothing in the videos that you've seen that suggests that Max is planning to do anything like an intentional homicide. There's nothing in the text messages that even comes close to suggesting that. Because of course, intent does have to be formed at some point, as they just said, and as the judge told you, before a person passes away. Nothing about the Twisted Fisherman video shows for 1 minute an intent to kill. And the same is true with Dukes. They go there, they're sitting at the edge of the bar, they're playing beer pong with another couple that shows up. Again, you can see, even if you want to watch the video again, you can see when Max leaves, he's saying goodbye to people that know him. Obviously, he used to work at Twisted Fisherman, we know, because he had to pick up his W-2 there. He's known at Duke.
And I'm not gonna lie, what he's saying are facts. The man, they went to places they knew, people treated them good. You can see him and her having a great date. They laughing. She sounds like she's having the time of her life. But somewhere it went wrong, and why it went wrong, we will never know. If he did it, we will never know what happened. Why? Y'all look like y'all was having a great time. She looked like she was fucking with y'all. And what we learned today, this wasn't their first date. They had been talking and dealing with each other. And there was one text where she said, I left my comb. And he said, I'll bring it to you when I see you Sunday. So that suggests they had gotten up prior. Or maybe she left it at the bar, whatever. But my point is, I would love to know why it went wrong, because it seemed like it was going so right.
Dukes. So this is not any evidence at all that Max intended to kill Sade. And like many people do, they went out after drinking and they went back to his house. We asked you in jury selection, all of you, we asked the question of whether or not you would insist that a defendant testify. Defendant has a constitutional right not to. It's a hard principle for some people to embrace. You don't have to testify. System doesn't require that. It's human nature. It's to want to hear sometimes, you know, like we say to our children sometimes, what did you do? What happened? Give me the side of your story. But that's how we handle things in our personal lives and not what is required here in court. And I am just going to address the elephant in the room. Max didn't testify, right? We all saw that. And maybe some of you were thinking to yourselves that you wanted to hear from him. Maybe all of you were thinking that. Certainly members of the public might have been thinking that. But he's not required to do that. The judge told you that. He's not required to give any explanation or prove his innocence System does not ever require a defendant to prove their innocence. Requires the state to prove that he intentionally killed her. I didn't see any evidence of intent when I sat through this trial. The state points out things that they say Mr. Anderson did after the fact, which would demonstrate, if he had done it, an intent to commit other crimes, mutilation of a corpse. But I didn't see anything, and I listened carefully, and I know all of you did too, that shows any intent to kill. And that's how it started, and now there's a reckless homicide charge you're supposed to consider as well, but I didn't see or hear any testimony about Mr. Anderson acting recklessly towards Sade at all. And those elements have to be proven. It has to be proven. In words, as the jury instruction said, words, actions, behavior before the event. Well, what are they pointing to? I'm asking that question. What are they pointing to? They're pointing to things afterwards that they say Mr. Anderson did, which they want you to bootstrap into a conviction on an intentional homicide. But that's not what the law says you're supposed to do. The law says you're supposed to look at each count separately. The law says that a defendant doesn't have to prove his innocence. The law says that they have to prove intent or recklessness beyond a reasonable doubt. The highest possible burden you could imagine. Not just that we think he might have done it, or last person with her could have done it, but that he intended to do it, or that he did it recklessly. And I don't know, based on this record, candidly, how she died. I don't know that any of us do. The medical examiner doesn't. Medical examiner is unable to tell us that answer. It's their job. Certainly the anthropologist we heard from doesn't know. And I talked about this with all of you in opening, that they have the burden to prove everything beyond a reasonable doubt. And if they don't, we don't have to put on any evidence. We don't have to put Max on the stand. We don't have to call witnesses to say A, B, and C. And I told you in opening, we weren't going to dispute, I forget what I said exactly, but I probably said we won't dispute 90+% of the case, because we don't. Everything Mr. Vance Curzan just showed you about the vehicle traveling to these locations, we dispute the big things, that it's Mr. Anderson intending to kill her or recklessly kill her. We dispute that he committed the other crimes, but the fact that they went on a date, the fact that they were together, the fact that they were friendly with each other, they drank, no dispute. The vehicle being shown on camera all over the place, the locations it went, no dispute. What we do dispute are a number of important points that I don't think have been proven. You never once see Max getting into this Honda Civic. Nor do you see him getting out of the Honda Civic. You don't see him get in and you don't see him get out. And there was a video that was played very early on in the trial that all of you will remember because it was day 1 or day 2, but there was a video of the Honda Civic when it is in flames, basically on Lisbon Avenue. We all remember that. And there's 2 women on the street who are on tape pointing in that direction. And you can obviously see that Max is in that area. I told you in opening, sometimes people can be in the wrong place at the wrong time. I don't have to prove, I have no burden to prove why Max was in that area. That is burden.
So, you're gonna sit there once again and remind the jury your client is guilty. You're gonna say, oh yeah, he was in the area where the car was burnt up. But the last time the car was seen at her house, bro, you suck, bro, as a lawyer. Oh my God, I would never allow you to be my lawyer ever in life. Bruh, don't say he in the wrong place at the wrong time. He dated a girl. Her car was at his house. Her car turns up burnt the next morning and you're gonna say, oh, he just happened to be in the wrong place. Bro, you a fucking idiot.
Burden shifting is not required. They have to prove that he was the one that exited the driver's door of that car and lit it on fire. They did not call either of those women in their case. They could have. They could have chosen to call either of those 2 women on the street.
You could have called those women too, or did you? I don't know. You didn't call no witnesses, brother.
Put them on the stand and say, is that the guy who lit the car? Or is that the guy walking near the car? Big difference. They could have asked him any question they wanted. Of course, we would have been able to ask questions too, but they could have put Her name is Laura Dyer. You heard that through other witnesses. They could have put Laura Dyer on the stand and asked her, who were you pointing to? What were you seeing? What did you observe in the minutes leading up to that? Who got out of the car? What side did they get out of, ma'am? What side did they get out of? If they got out of the car, how did they light the car on fire? You could have asked all of those questions and answered all of those questions for you. And we know for sure that she was shown a photo array because I asked one of the detectives about the photo array procedure. We know for sure it was shown, and they didn't introduce it. I'm not here to hide a thing. Study it all. Study every piece of evidence that they gave you in this case. But they didn't call Laura Dyer, who I would argue would be the one witness you would call.
But you didn't call her neither, bro. So I don't get your point. You telling the jury, oh, they didn't call such and such witness. You know, she could have told you who was in the car and who was out. Well, if you was a good lawyer, you already talked to her. So, as a juror, it would be safe for me to assume she didn't say what you wanted her to say. That's why the defense did not call no motherfucking witnesses. So you're asking the jury to be stupid. Well, the state didn't call her. You didn't either, bro. If she had information to free your client, you didn't call her neither. You didn't call not one witness.
In your case, if you wanted to prove that Max lit that car on fire, instead of being near it. And if we work from there forward, if we look at his behavior afterwards, Max's behavior, it's Max there, his behavior afterwards, they haven't proven what was in his backpack. But if we look at his behavior afterwards, he is not, as they just said, concealing his identity. Now, if you lit a car on fire, there's 4 ways you can go: north, south, east, or west. And I would argue that the last direction you would go is right down to Lisbon Avenue if you did that, onto a public street with cars whizzing by and buzzes everywhere and getting on a public bus. Actually, if you looked at the video, there's an alley right there. The more logical way to go is just dart up through that alley, get away, duck through houses and backyards and run. Max is walking. But look at his shoes, because their theory that they've given you in this case is that Max, prior to this, first of all, their theory is he killed her in his house without Pete Warbington hearing a thing, who's right below him. No struggle, no stabbing, no nothing, no help, nothing. But their theory is he killed her there. But then in the rainy day, pouring rain for days, muddy path down to Warnemont Beach, their theory is that Max did all of that. Why on earth, when he is walking on Lisbon Avenue, and you can watch the videos, look at the shoes. They're pure white soles. At least the sides, even the detectives testified to that. His shoes are white. Somebody who has been trudging through the mud, dispersing body parts in Warnemont Park in the pouring rain, in the bad conditions, does not have white shoes. No way. Muddy shoes, for sure. Watch the whole bus video. He doesn't, as they said, he doesn't pull out a phone or he sits there the whole time. Shoes are white. That is inconsistent with somebody having been at Warnemont Beach earlier and doing all of these things just a few hours earlier that they say. The sweatshirt that was located in the trash can, we had some testimony a few days about that. I don't know what to make of that. I don't know if it was planted. I don't know how that sweatshirt got in that trash can. But I know that if somebody was trying to destroy evidence, they could burn it right in the backyard. There's a burn pit right there, and they would be unlikely to ditch it right in the alley 2 houses down from them. Seems like a really unlikely thing to do. But what you didn't hear about the sweatshirt, and we know it's found on April 12th, after Max has been arrested. He was arrested on April 4th. So 8 days later, they find this sweatshirt. And how on earth is a detective, I think it was Lopez, how on earth is a detective on April 8th? He told you his job was to go down this alley to look in the trash cans. Remember, he was going to go look for clothes or evidence. If you were going down an alley to look for clothes or evidence, and he's now telling you, I remember seeing a sweatshirt in a trash can, but I just left it there. His job was to look for a sweatshirt or any clothes. I just find it really hard to believe. I think he's not being honest when he says that. I find it really hard to believe that if you found a sweatshirt in a trash can when that was your job to go the alley behind Max's home, you would grab it. And the trash came through on April 8th. Max is in jail. And there is none of Sade's blood on that sweatshirt. We were just told, again, he's wearing that sweatshirt supposedly when he dismembered a human corpse. The amount of blood and bodily fluid that would require, look at the video of him on the bus. If you can see a speck, there's no gloves on him. There are gloves at Warnemont Beach, which exclude him, but there's no blood on him at all. There's nothing on his hands. He's not wearing gloves. Max's DNA is also not on the driver's door of Sade's car, which is lit on fire, but her DNA is. So if their theory is that the DNA on the car driver's door was washed off by the fire department, why is Sade's DNA there? And his isn't. It's because he didn't close the driver's door. It was in the wrong place at the wrong time. And they swabbed everything. It was really boring. Some of the aspects of the trial were really boring for all of us because you had to sit here and watch grainy videos of what a detective thinks they see upstairs, and you have to listen to us on our end bore you, unfortunately, at times by going through all of the DNA evidence. But for crying out loud, this was the most swabbed home I've ever seen in my life. Swabbed everything. Everything. Ask for the report. None of Sade's blood is anywhere in that home. But she's been stabbed. He doesn't have any blood on him at all for a stabbing? And they don't have any weapon that they can connect to him that was...
I mean, the bloody clothes could be in that backpack that we never found. I'm just saying. But we never found it, so I guess he's right. Like, he should be bloody, and he should be all these things. It's just interesting. It's going to be interesting to see how the jury rules.
He ever used for this stabbing? Or however she died, they don't know. But they do know for sure the DNA excludes him. It excludes him because her blood isn't in his home. Her DNA isn't anywhere in there. There's no smell of bleach. There's no indication he cleaned up. I would argue this does not look like a cleaned up place at all. Look at the photos. And there was a hair found on a proximal bone, one of Sade's bones, the hair that was found, and they thought for sure that's going to be Max's hair. We have a hair on a bone. I guarantee that's why they tested it. And look at the report. The hair on one of Sade's bones excluded him. Wasn't his. The video of the house, there's look at the pictures if you want to. It's grainy, it's poor quality. I also heard Rachel Smith said she spent 100 hours or whatever she said about the quantity of hours looking at video. The reality about the video is, again, we don't dispute that Max and Sade went back to his house. We don't dispute that they were there. Which silhouette is what or what it shows, your guess is as good as mine. I know that the FBI could look at it if they wanted to, and was never asked of them to do that. They offer a witness with no specialized training in an effort to convict Max of homicide to say, well, I saw this silhouette and that silhouette, but they didn't do any height analysis. They didn't ask the FBI to be involved, and it doesn't show anything that we don't already agree happened. They were back together. But that front window is piled full of plants and other debris and miscellaneous things in there, so it's unlikely that there's really a whole lot of interaction you can truly see. It's probably dogs run around. I don't think Max is so sophisticated of a guy representing him. We heard from Pete Warbington. I don't know that Max is the most sophisticated guy out here. He's a smart guy, but he's working 3 days a week. He's a bartender. And Pete Warbington says, I complain about a hydraulic arm. He won't fix it. And Max doesn't like hearing that he's a bad landlord. I know. But the reality is that he's not a highly sophisticated guy where they introduced all sorts of evidence of his planning and research on wanting to kill someone. 30-some years living in the area, working for a decade as a bartender, well-known throughout the city. They didn't introduce one weird thing about him. No psychological profile evidence to show you that he fits the pattern of someone who's going to just decide, I'm going to kill someone tonight. after a date where I went everywhere that everybody knows me, and I've never researched it, and I've never looked into it, nor have I even so much as looked at how to dispose of a body or remove body parts, which you can only imagine what kind of feat that is. Use your common knowledge of even examples you can think of cooking about how hard it might be at Thanksgiving to remove a turkey leg, let alone a human. No research on it, no planning on it at all. Again, that's because he didn't have any such plan to do anything like that. It's not that secret of a beach either, if I can just say that. I mean, a few hours after someone is down there in the rain and the horrible conditions, there's 2 kids there a few hours later in that same spot, right? They're there. They find a bone or a leg. So it's not that secret. It's Warnemont Park. It's a public park, 18-hole golf course. Everybody in the community is familiar with that area. Officer Desmet testified, he's very familiar with the park. People go there all the time. We have 2 youngsters there right away a few hours later finding human remains. So not exactly a secret area that nobody's ever heard of before. What is Max's behavior afterwards? A lot of times in our human affairs, and Judge State has told you, use your common sense. The reason they keep saying common sense, and again, I didn't tell you not to use common sense. I talked about this in opening. Go ahead and use it. Use it galore. But also, please look at the evidence. You have to do more than just base things on this expression, common sense, okay? Look at the evidence. We do know that somebody who committed a crime like this, who had done something like this, when they haven't, would be highly likely to change something about their life. He didn't do any such thing. He continued to go about his day-to-day affairs. You heard that he went to work at Dugout 54 the next morning, and his phone died, not turned off intentionally. It died during the hours that one would be asleep. And he went to Dugout 54, and he worked at Dugout 54, which was his job the next day. No issue. You didn't hear from one person who said that suddenly his behavior was different or that he started acting strange. He continued to work, stay in the area, didn't cut his hair, didn't change his appearance, didn't have a whole pile of cash in his car with a passport to Mexico, none of that. Just going about his day-to-day affairs. That's because he's innocent. And the police are the ones who make a decision on what to collect and what not to collect. And they give you that evidence, and then you decide whether it is proof beyond a reasonable doubt. They could have asked for more footage if they wanted to see what was going on the side of Max's house in the days after, or the alley in the days after. Does he ditch a sweatshirt in a trash can? But they chose not to, because they zeroed in on him, they zeroed in on a time frame, and that was all they needed to do. I know that when the evidence shows that when Sade's car left Max's house, and you never see him driving that car, when it left that house, and we know things can happen in an alley, when the car left that home, it went straight to Sade Robinson's apartment building. I never said it went there, to be clear. I never said she went in there. I'm just saying, what are the odds that with no evidence he even knew where she lived, that Civic goes from his home right past the building she lives in? A hell of a coincidence. I think it's very likely that perhaps something happened to her in the alley and perhaps she was directing them where to go. I don't know, but I do know maybe it was a stalker. But whoever did it obviously had an idea where she lived because they went right from point A to point B. I think the reason that the state spent such little time talking about the DNA evidence for you is because they know how powerful it is for the defense case. But we don't have to prove that DNA proves prove his innocence. They have to prove beyond a reasonable doubt that he's guilty of each of these crimes, that he intended to kill her. Now they're saying recklessly, but either one, whichever one they're saying. They had to form that intent or that reckless decision before. There's no evidence, by the way, of any reckless behavior at all that they've shown you on video, that they've shown in his house, that they've shown at all. But the reason why they spend so little time on DNA and they sort of brush past that, and yet they'll spend days and days and days going through monotonous video of things we don't dispute, is because they know that the DNA evidence is powerful for us. And I ask that you look at the evidence closely. That's all I can do. I turn Max over to you. It's your decision. You have to look at each count carefully, and I'm convinced you'll conclude that the state hasn't met its burden of proof on each count. Thank you.
State any rebuttal?
Sure. Ladies and gentlemen, the reason Maxwell Anderson went to work the next day and didn't cut his hair or do any of that stuff is because he thought he got away with it. Because he did it alone. He did it in the middle of the night. So leaving town, doing that stuff, that brings attention to yourself. That's also why he sends that text message to her the next morning. Hey, morning, how's work going? He's trying to cover up. He thought he was going to get away with it. That's the whole point. Because everything he did the night of this incident was done in the middle of the night in a secluded place that he knew was secluded, that he took her to and cut her up. He thought he got away with it. Let's talk about blood. You saw the images of her on that couch. She's out of it. She is gone. There's no blood in there. You heard from the medical examiner how people can die without blood. Strangulation, suffocation. It's no coincidence that she is face down in his cushions in those. That she is so out of it that he's able to lift her shirt up and grab her breast and yank her pants off without her putting up a struggle. We know as well that the dismemberment, remember the medical examiner talking about the vital reactions, that there were no vital reactions at the areas of amputation. That means no bleeding, because she was dead when it happened. And he's doing it down at the lakefront on the shores of a lake on a rainy night. And he talks about no mud, no blood on the shoes or anything like that. He's got this massive backpack with him that he gets rid of, that has never been found. Why? If that backpack is something that's important enough for you to go out at in the middle of the night with, why is it gone? Because he got rid of it. He got rid of it to cover up the crime. The hoodie. Why is it in someone else's dumpster? Why is the hoodie not a hoodie you were wearing while on the date, but a hoodie you're driving around in the middle of the night with? Why is it in a dumpster 2 houses down? Why is her DNA on it? It's because he's the one driving her car around, taking her body to Warnemont Park. No intent to kill?
That's one thing, you know, reasonable doubt. They say you gotta have reasonable doubt. I don't think he was smart enough to go down to the beach, cut her up at the beach. Imagine if he did it at the edge of the water. All the blood is just gonna wash out into the water, right? But then he threw a sweater in a trash can 2 houses down. I just don't see that. He did a whole bunch of other shit, but then he just threw the sweater next door. That doesn't even make sense. But who am I? I'm nobody.
What about all the horrible, disgusting, gruesome things that he did to her body? That shows intent to kill.
He did a whole bunch of other shit, but
He brought up this hair on the proximal bone, and his argument was Max was excluded from that hair. Do you remember whose hair that was? It was Sade's hair. He failed to mention that part just now. Just like he failed to bring up the latex gloves he brought up in his opening and said, certainly these gloves played a role in this crime. That was a quote. What a joke. Those gloves had nothing to do with this crime. Nothing. The blood on those gloves was neither Max nor Sade's. It's located a quarter-mile south of where this occurred. A week later, a smoke screen. Nothing to do with this crime. Maxwell Anderson was not walking away from the Honda Civic because he's in the wrong place at the wrong time. Why on earth is he walking around behind an abandoned building where the woman who he was on a date with the night before's car is getting set into flames and he's just casually walking away? And you did hear from the woman who saw him do it. You heard her on the video. You saw her point to him and say, he did it. Call the fire department. What's that all about? It's because he's the one who lit the car on fire to cover up all of this and calmly walk away because he's trying to get away. He's trying not to draw attention to himself. Asking you to completely speculate that something happened to her in the alley. Well, let me ask you this. How does she get in the alley if she's passed out of it, incapacitated on his couch? How would she have even gotten there? He's asking you to speculate. She's just instructed you, you can't speculate. You are not to speculate. That's what he wants you to do. That's what he wants you to do to find Maxwell Anderson not guilty, but you can't. You follow the evidence. Not a single piece of evidence points to anybody else. Everything at every single turn, even when police tried to focus on other things, like the latex glove, did it lead anywhere else except back to him? The broken pieces of car at the gate just happened to match the Honda that he's walking away from as it lights on fire. The beach where she is cut up, it's his beach. It's his place. Every single lead, every single thing the investigators did led back to Maxwell Anderson, and it is because Maxwell Anderson is the killer. He is responsible, so find him guilty.
I ain't laughing, but the family be back there clapping like they at a movie, but I get it. Their loved one was killed and they want justice.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. I've instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of the case is to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, passion, or prejudice. You will be careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequence of your verdicts are matters for me alone to decide and must not affect your deliberations. There will be 9 forms of verdict submitted to you regarding the charges against the defendant. As to count 1, there will be 3 verdicts. The first verdict reads, we, the jury, find Maxwell Anderson guilty of first-degree intentional homicide as charged in count 1. Another reading is, we, the jury, find the defendant Maxwell Anderson guilty of first-degree reckless homicide in violation of section 940.02 sub 1 of the Criminal Code of Wisconsin at the time and place charged in count 1 of the information. And a third reading, we, the jury, find the defendant Maxwell Anderson not guilty. As to count 2, there are 2 verdicts. We, the jury, find the defendant Maxwell Anderson guilty of mutilating a corpse as charged in count 2. Another reading, we, the jury, find the defendant Maxwell Anderson not guilty of mutilating a corpse as charged in count 2. As to count 3, there's 2 verdicts. We, the jury, find the defendant Maxwell Anderson guilty of arson of property other than a building as charged in count 3 of the information. Another reading, we, the jury, find the defendant Maxwell Anderson not guilty of arson of property other than a building as charged in count 3 of the information. Lastly, as to count 4, there's 2 verdicts. We, the jury, find the defendant guilty of hiding a corpse as charged in count 4, and another reading, we, the jury, find the defendant not guilty of hiding a corpse as charged in count 4. You are to bring in 1 verdict per count. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count in the information. Each count carries a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. Now, this is a criminal, not a civil matter. Therefore, before the jury may return a verdict that lawfully may be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a legal verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than that of any other jurors. If you need to communicate with me while you're deliberating, have the presiding juror send a note, time-stamped and signed by the presiding juror with your question. It may take some time to answer because I may consult with the attorneys before I respond, so you should continue your deliberations while you're waiting for a response. I will answer all of your questions either in writing or I'll bring you back into the courtroom and answer them on open record. When you've agreed upon your verdict, have it signed and dated by the presiding juror. Notify my bailiffs that a verdict has been reached. Everyone will return to the courtroom and your verdict will be read into the record in open court. I may ask each of you if you agree with the verdict. It's 4:37. I think we'll begin the deliberations. Okay. At this point, we're going to select our two alternates. So, three alternates. So all of your numbers are inside of this box. Juror number
53.
Who's 53? Okay. Your first alternate.
38.
Second alternate.
And the last one, 26.
Okay, the three of you are my alternates. So at this point, your service is complete for the next 4 years. If you need a notice for your employment that you've been here with us, you'll have to go back to jury management to get that. Otherwise, it'll come out to you in the mail in about 2 to 3 days. Now, you're not allowed to speak to any of the other jurors, but after you leave here, you're free to speak to anyone that you wish or to no one. It is completely up to you. If you wish to return to the courtroom and wait for the verdict, you're welcome to. If you want to call my court at a later point and find out what happened, you're welcome to as well. Or you're welcome to check CCAP. Now, do the three of you have anything in my jury room? Okay, I need to release the three of you before I release the other jurors. So thank you for your time and attention and service. I've used alternates way too often, so I appreciate you being here. You're not allowed to communicate with the other jurors at this time. Thank you.
I'm a little confused. Maybe I'm just dumb. They picked 3 alternates. I thought the alternates are if something happens to the main jurors. So why would they leave? I'm confused. Because I'm just saying, why would they leave? Okay, y'all have 15 jurors just in case something happened, right? You just pick 3 of them as your alternates. So what are you saying? You can't lose a juror during this process? What if in the middle of this process somebody has a heart attack and what you gonna call back? One of those 3? I don't know. Maybe I'm just dumb.
At this point, we will swear the bailiffs.
Do you solemnly swear that you will keep jurors on this trial together in some private place and that you will not, before they render their verdict, communicate the state of their deliberations or the verdict they have agreed upon? So help you God? I do. Thank you.
Okay, you may begin your deliberations. Any objection as to how the jury instructions were read into the record, State? No. Defense?
No.
I did find on the jury instructions one correction, which was on the last page relative to the verdicts. It said 4 verdicts will be provided. I changed it to 9, and I just wrote it on it. So that was the only modification I made. I plan on recalling the jury at about 3 minutes to 5 if we don't have something happen quickly. So please, if you could stick around, I'd appreciate it. Also, if you could go through the list of exhibits and see if there's anything, if there's a request you're willing to send back without further discussion, and a stack of course, anything that you wish to be addressed on. Of course, no videos would ever be sent back or physical evidence without the bailiffs. Case was well tried. Thank you, everybody. Thank you.
Hi, if you could switch me back to live desk feeding into itself, I'm going to do something from here again now for IFB. Thank you. Okay, bye. Thanks. And it looks like I am already up and running. Folks, I'm Brian Polson at the Wisconsin Live Desk. The closing arguments just wrapped up here in the trial of Maxwell Anderson, and the jury is now deliberating. We thought, the judge said earlier, she was probably going to wait until tomorrow to start deliberations, but things really sped up this afternoon, particularly when the defense decided not to call